She put something together. So there's no voting,
Okay,
or do we have voting?
good morning. Call House Finance Committee to order. We're here for a public hearing on a non-germane amendment. I would like to welcome Chuck Grassi, our new member, to the Finance Committee, replacing Hatch. And I will call on Representative J.R. Hole to introduce amendment number 0767H.
Thank you, Mr. Chair. Here to introduce, as you just said, 20230767H. I'm going to be looking at both the amendment and then there's a side-by-side comparison between this and an amendment that Division 3 had worked on prior that was the foundation for the changes to this. In the original amendment, which was 804, we were looking at 6 to 12 beds. This plan is an operate 12 beds only in 076H. It makes, and the reason that this is a non-germane amendment is on page 2 of the comparison. It has to do with a bill that was adopted by the prior legislature, House Bill 254, out of the House, but I don't think became law, relative to who could be committed to the Sununu Center. And this is where it starts to change from the current list of people and the various crimes that they could be committed under to the most serious of crimes, right? All of the crimes against a person that are significant, murder, sexual assault, all of those type crimes, and not all of the ones that are currently things that would be a Class A misdemeanor because of stealing an iPad, right? The value of goods has changed so significantly over time, and we haven't kept up with the laws, that potentially you could incarcerate kids for very serious crimes, but very serious being defined by the value of an item. And there is at least some information that has been presented to the committee that incarcerating youth under those conditions actually causes more harm in the long term. It doesn't help them rehabilitate. So if we limit the number of crimes that people are going to the Sununu Center, we can keep the population lower, down at the 12 beds. With that, I'll close my testimony unless there's any other questions.
Any questions for Representative Hole? Representative Edwards.
Thank you, Mr. Chair, and thank you, Representative Hole. Are you aware that both the chair and vice chair of Children and Family Law have HB 120 retained in their committee, and they have they would be here except for they're in exec session right now voting, but they have both told me that they would prefer that any changes to the criminal statutes be sent to them because they've not had an opportunity to hear it this term, and they think it's more appropriate for their jurisdiction than the Finance Committee. Have you heard that?
Thank you, Chairman Edwards. Yes, I have heard that. And we're dealing with the finance side. We're not a policy committee. The current cost, we're looking at like 87. I think the budget request was 87 people for the roughly 12 on average children that are in the Sununu Center. We're looking at an operating budget that's somewhere between $10 and $12 million, right? So this is, our incarceration costs are somewhere between $800,000 and $1 million per child. We should be looking at what is the appropriate list to put in the center given the extraordinarily high costs for incarceration of youth. And that was talked about in this amendment in particular regarding staffing ratios and designing a building that long-term would be set up and strategically to have lower staffing ratios. I mean, having 87 people for roughly 12 children on average is almost 8 staff members per child. That's a huge number. So I think there may be a way long term to keep the costs in line. But yes, to your point, to your question exactly, that policy question was historically won by children and family law, but it might need to be taken up this time around here because of the impact on the total cost of the facility for both design and operation.
Further questions from the committee? Seeing none. Thank you, Representative Hall. We'll next call on Representative Bob Lynn.
Thank you, Mr. Chairman, members of the committee. When I signed up to testify on this bill, signed the pink card, it said, do you support or do you oppose? And I was really in a quandary about exactly what to say, because I very strongly support the overall thrust of this bill to close the Sununu Center and build a new facility and build it in accordance with the terms that are set out in the bill. I have concerns about what I would refer to as the 254 aspect of it. That's the bill number from last year that purports to change the crimes for which a person can be committed. And I guess I would say I've had extensive discussions with Representative Irf and Representative Edwards about this, and I think that the proposal as it is reflected in the amendment that was just referred to by Representative Hall, I'm all right with that. I think that is okay in the sense that my main concern last year and this year has been that there was a prior version that would have excluded any potential for someone being committed for serious property crimes, no matter how serious. And so the example the example I've used before, and I think really would highlight this, is if a juvenile, even a juvenile with a serious prior record, were to come in and burglarize your home when you weren't there, so there was no danger of physical harm, but literally clean out your home, destroy it, unless the terms that were included in the most recent amendment that Representative Hall proposed, there would be no possibility of a juvenile being able to be committed for even one day, and it just seems to me that doesn't make sense. So I guess bottom line is I think the proposed amendment is sort of acceptable, with one caveat, and that is that, and I've talked to Representative Irf about this, and I've actually submitted a proposed amendment, which I think maybe Representative Edwards may talk about at some point. Right now, the proposal allows for commitments of juveniles for certain offenses that are specified in Section 169B 19 1J and 1M. In order to have the bill make sense, you need to make a similar change in terms of for what offenses can somebody be detained. But unfortunately, that is not in the bill right now. It is in my amendment. I think my amendment is number 892. But if you don't make that change, you could literally have a situation. I think and this to me just sounds crazy. It doesn't make any sense. You could literally have a situation where a juvenile is arrested for a very serious property crime, or maybe even some other crime that's very serious, but is not among the ones that are listed in J. And you could have a situation where everybody knows from the outset that this is an offense that merits the child is going to get some period of commitment at a secure facility, and yet the judge has no power, as a matter of law, would be precluded from detaining the child. So I mean, literally, this is maybe I'm I'm making up a, sort of an absurd situation, but literally under the law, this would apply. You could have that situation like that I gave, the example of the judge, of the person trashing the house when you're not home. The person could literally be charged with, under subsection M, come into court for the preliminary hearing and tell the judge, listen, judge, I'm not going to show up. What are you going to do about it? And the answer, the judge would have to say nothing, because the law, if you don't make the change that I've suggested, the law would be sorry. Even though everybody knows that this is a very serious crime, a very serious juvenile offense that the person might be committed for, or would be committed for, you have to let the person. You cannot impose a detention. You can impose some other things, but you can't impose detention, which to me doesn't make sense. The last point I would make, and I have to say honestly, I had not thought about this, but I hope you'll pay really careful attention to what Director Ribson has to say, because he raises a very good point about the situation of changing the law from what it is now to remove things which both my amendment and Representative Hoole's amendment do, to remove simple assault from the offenses that are potentially the basis for detention or commitment. And he gives really good examples of sometimes there are situations, not very often, doesn't happen often, but sometimes there can be situations, and I think he gave the example of a child that assaults his parents, and the child there aren't any other family members available, or there isn't foster care or whatever available. And if the law is that that in those circumstances, the court can't commit the juvenile to a secure facility even for a few days, then what happens? I mean, what are you going to do in that kind of situation? Is the juvenile can't go home. So it just seems to me that to make the law so strict that it doesn't have the flexibility to accommodate that, I think is really problematic. And I guess then the last thing that I would say is this. I think there's much to Representative Edwards' point about this aspect of this bill not having gone to the policy committee for review. And I would also note, I think it's important to note this. It seems to me getting the Sununu Center done, the new Sununu Center done, is crucial. It's got to be a number one priority. And I think that injecting this aspect into this puts that, at least to some extent, at risk. Because my impression is that the Senate may not have the same view about this 254 aspect of this as these proposed amendments do. And why raise that issue? Why not have that just as a separate matter? Get the Sununu Center built, a new one done, and then deal with this as a separate issue. That would be my suggestion. But anyway, thank you. That's all I have to say.
Questions from any committee member? Representative Edwards, and then Representative McGuire.
Thank you, Mr. Chair. I think there's a couple, three questions I'd like to ask Representative Lynn that are all related to one another. I'm a little confused by your testimony, sir. At one point, I thought I heard you say that you support Amendment 0767, and then as you continued to talk, it sounded to me like you weren't really in support because you had concerns about how simple assault and property crimes might be treated. And so I just want to make sure I'm clear on what your position is. Is it yes or no on 0767?
So I guess what I meant to say is 0767, I think, is an improvement over the bill that didn't have any potential for property crimes. But I think it is. I could not support it if the terms of that changed that would allow detention are not included, and those are only included in the amendment that I proposed, which is I think 892. So without that, I could not support 767. The other point that I would make is Although with that change, I could support 767. I think that that Director Ribson has very valid concerns about excluding simple assault. If is it something that would cause me to vote against this bill if it came to the floor, assuming the other changes were made? I don't know, but I think he does have valid concerns that I think you should pay close attention to.
Follow up.
Follow up.
So I've heard you mention a couple of times that you have an amendment that you think improves 0767, and I guess the question is to the chair, at what point should we be entertaining that alternative that Representative Lynn thinks may be an improvement?
I don't have a copy of it. Mr. Ripple, do you? All right. We'll finish the hearing on 767 before we introduce the next one.
And then I have just
Another question?
yes, sir. This is sort of my final one in this bucket. Representative Lynn, I have, in talking to people about the changes and narrowing of the possible charges under which somebody may be detained or committed to the new center, I've heard concerns that if we narrow it, in the real world, what we may end up having is the unintended consequences of having prosecutors or judges thinking that the kid needs to be put somewhere safe for public safety, and that may tend to cause overcharging to be taking place. And if that is true, I'd like to know if you think that may be a valid concern, and if it is a valid concern, might we end up doing sort of some harm to some kids because they end up getting overcharged?
I think that's a very real concern. I mean, if you put yourself in the position of a prosecutor and in the first instance, and maybe a judge, if the circumstances are such that it's clear to the prosecutor and later down the road to the judge that this person needs to be detained or needs to be committed, and the law, the law of, let's say, of charging it as a misdemeanor just completely precludes that, then the prosecutor is going to make may very well make a very strong effort to charge it as a felony. And so, the question, I guess, is, do you really want to sort of tie the prosecutor's hands so that's the only alternative you leave him? I would suggest that you shouldn't want to do that, and particularly I would suggest that you shouldn't want to do that where under the existing law you've had such a very significant reduction in the population of the current Sununu Center. That's under existing law. So it tends to show that, prosecutors and judges are exercising their discretion appropriately.
Further question?
So thank you. I wasn't going to ask this, but I think it dovetails nicely with that last remark. Is it a correct understanding that currently under the existing New Hampshire law that this state holds the high honor of having the very lowest level in the nation in terms of per capita kids being committed or detained? We're already number one in the lowest. How low can you go?
I have not done any independent investigation of that, but I've heard that that's true. And I guess just one other point that I would make on that is and maybe some other witnesses, if they've done further research, can correct me, but at least as of last year, I know that from other I haven't done any independent investigation of this, but from things that other people have said, it's my understanding that if you were to adopt the new changes that are proposed to further restrict offenses that can be the basis of commitment, no other state has gone that far. Illinois, I think, has come the closest, but no other state will have gone as far as we have gone.
Thank you, Mr. Chair.
Representative McGuire for question.
Thank you, Mr. Chairman. Thank you, Representative. But isn't there a connection between the list of crimes that can cause commitment and the size of facility that we need, and the fact that the number assigned to the facility has gone down, you're attributing it to the attitudes of judges now. But if the law doesn't do that restriction, could later judges start ballooning the number, and now we have a facility that's inadequate?
Well, I mean, is it possible that judges in the future will begin to act unreasonably? I suppose, yes, I suppose it is. And I suppose if they do, then that would be the time to change the law. But given that, you know, with the existing law, the population has gone down tremendously, because I think, you know, everybody has sort of thought that, you know, that has had a different attitude about the way that juvenile offenders should be dealt with. And I think that's a pretty broad, you know, sort of across the board spectrum of where people stand on that.
Further questions from committee members? Seeing none, thank you, Representative Lynn.
Thank you.
We'll next call on Representative Marjorie Smith.
Thank you, Mr. Chairman. Marjorie Smith, representing Durham. I'm in my 13th term, and for many of those terms, I sat where you are sitting now with any number of you on the committee. For 2 of those terms, I was chair of this committee. And it is because of that my conscience weighs so heavily on me, because we have known for many years of what was happening at the Sununu Center, and for any number of reasons were unable to find a way out. My conscience is heavy. There was a time when the department wanted to have young people, children who were in Sununu, eligible for Medicaid, not necessarily because they wanted to have access to health care for them, but because they wanted the revenue. The federal government came in and we met with them, and they refused to go along, not because there was barbed wire around Sununu, which is one prima facie reason why you would not be eligible for Medicaid, but because within the facility itself, the people who were operating the facility then were violating not just federal law, but state law. For example, and I'll give just one, the federal representative said, you are restraining juveniles in your facility and you're putting juveniles into solitary confinement. And the state representative said, well, yeah, but we're working on that. We're trying to figure out how we can find something else to do. In violation of what the law that we in this body had passed, that juveniles should not be restrained. We're not talking here about baseball. We're not talking here about if you build it, they will come. We're talking about young people who are in a system that is separate from the adult system, because we all know, and each year we find more research that makes clear that juvenile brains are not fully developed. And juveniles cannot be held or should not be held accountable to the same standards that you must hold adults. I've listened to words this morning including crimes and criminals. Juveniles are not criminals, they are juveniles, and that is very, very different. Do we have horribly troubled, confused young people? Of course we do. And we know that. Do we know that the worst thing we can do is to institutionalize those young people, particularly with other people who have some of the same problems, take them out of their own communities, deny them the opportunity to try to find a way through to where they could become responsible adults. So my concern is, I disagree, as you can well imagine, with the Senate approach of saying the more the merrier. I think we should have the smallest possible system. I think we should have a system that makes sure that to the greatest extent possible, children are cared for in their own communities. Perhaps not in their own homes, but certainly in their own communities, because we want them to be able to come back and function as adults in those communities. And that is why we created a juvenile system years ago. With all due respect to my current chair on Judiciary Committee, I think that the attempts that are being made in this amendment to recognize that, yes, we need a facility for juveniles, but we need it to be small. We needed to make sure that behaviors which are certainly not acceptable to an adult and certainly are not acceptable for children are treated in a way that acknowledges the difference between a juvenile brain and an adult brain. I was interested to hear the Representative Edwards. I don't like to, I mean, he's just left the room, but talk about the Child and Family Law Committee wanting to have this bill to talk about the crimes. Because if we're talking about crimes, then I think the bill should go to criminal justice. But if we're talking about juveniles, then I think that we see the difference right there between an adult and a child. And as a longtime member of this committee and chair of this committee, I go back to what Representative McGuire talked about. We have very limited dollars available in this state, and we have to use standards that are very clear and are designed to make sure that we meet the essential needs of the citizens of the state and no more. The cost that we are incurring in operating the Sununu Center the way we are now is really not justifiable when we see the long list of other issues that do demand public attention. So I hope that you will support this effort, which, as you can see clearly, is it's not just a bipartisan effort, it's a nonpartisan effort to put young people who are in trouble and need help first, and help us find a way to bring those young people back into society where they can be productive members. So yes, I support this amendment, and I thank you for your time.
Thank you. Questions from the committee members? Seeing none, thank you, Representative Smith.
Thank you, Mr. Chair.
We'll next call on Director Joe Ribson of the Department of Children, Youth, and Family.
Good morning, everybody. Joe Ripsum, Director, DCYF. Good to see this committee on this issue for, I don't know, third time, and our Division 3 colleagues for, I don't know, 8th, 9th, 10th time this session. So glad to continue the conversation. Hopefully we can get across the finish line with something that works for kids and families here. So I do have, I first want to be clear, we very strongly support the replacement of SYSC with a smaller, trauma-informed program, ideally co-located near a facility where we could share services and drive down operational costs, but also ideally share services that mutually benefit the two programs. So, for example, if this was to be co-located near, say, Hampstead, you would have common clinical, common education, et cetera. If it was to be co-located near the hospital, New Hampshire Hospital, you wouldn't be able to share those clinical and education services, but you'd be able to share other types of services to help drive down the operational costs. But there are many things in this amendment that I am very, very worried about. And I'm going to just try to quickly go through. Some of them I'm less worried about than others, but I'm going to mention them just so that folks have that information for the future. Page 2, line 1. That talks about changing the name of the facility. I have no problem with changing the name of the facility, but the purpose of that line was not to actually rename the facility. The purpose of that line was to make sure that the new facility lined up with the rest of the statutory scheme in terms of a youth development center, which is how the rest of the statute refers to this facility. So if folks want to change the name to juvenile treatment center, I wouldn't object, but somebody then has to do the find and replace through the rest of the statutory scheme to make sure that those things are lined up. Page 2, line 24, I have really big concerns about this. So, as Representative Edwards mentioned, as Representative Lynn mentioned, we currently have the lowest rate of detention and commitment in the country. That's because of a couple things, and Representative McGuire mentioned, that the law needs to align with what our expectations are for what kids can be detained or committed. I would say that that's happened largely already, and I'll go into more detail about that in a minute. And that's part of what has driven down the need for a detention or commitment. The other big piece, as I've shared with the committee in the past and won't go super deep on, is the creation of a system of care that's actually allowing us to care overwhelmingly for kids in their own communities, right? When I came to this state 5 years ago, we typically had 70 kids in that building. Today, we typically have 12. When I came to the state 5 years ago, we typically had 200 juveniles in residential programs, juvenile justice youth in residential programs. Today, we have about 110. So the use of institutionalization as a remedy for juvenile justice has gone down radically. And not just because of the change in the law, though that was part of it, also because we've built a robust system of care for behavioral health that's meeting kids' needs where they are based on their needs and not based on the offenses that they committed, which is the right way to do this work. I'm not going to go too deep in that, but what that ends up resulting in is the few kids that do get sent to SYSC are very, very high needs and very, very intense. When you look at staffing ratios, which shall not exceed those supported by national accrediting bodies in K, I'm very worried for a couple things. One, I don't know what these national accrediting bodies are because most juvenile detention centers are not accredited by a national entity. So I'm not even sure what standards they're talking about. But if you Google staffing ratios for juvenile justice entities, what they'll point to is the PREA standards, the Prison Rape Elimination Act standards, which is a 1-to-8 ratio, 1 staff to 8 youth. We currently have 12 very high needs in that facility. If we were to be operating under a PREA standard of 1-to-8, we would have 2 staff for that building. That would be absolutely absurd. We would have law enforcement needs 24/7 to keep that building just safe, and we would never, ever come close to being able to implement the trauma-informed care that this bill talks about. So I think I have really big problems with that. Maybe the drafters had a different idea about what that meant, but that's how I would read this, and I think we need to be very, very cautious about that. The next 3 lines here, 25 through 27, I don't really have a problem with us talking about using this. I would just say that we did consult this as part of the process that happened 18 months ago when we came up with this plan in the first place, and that there are other parts of this plan that we would continue to consult as we move through the rest of a closure of the facility. The other things I would mention, though, is that this plan was really drafted not with the intent of closing the only secured facility in the state, which is what we're talking about here, but it was drafted when talking about closing one of many secured facilities in a state, right? How do you make the choice between the 20 facilities that you're operating? Which one is the one to close? So there's a lot of things in this plan that aren't even applicable to our situation. That being said, the things that are applicable we looked at. The other point I'd mention is we're actually been invited to this organization's conference in 2 months to present on how we've done this work better than any other state in the country. So, I don't really have a problem with including this in here, but right, the meaning isn't all that significant for our current work. And then I would move forward to page 5, line 11 through 15. So page 5, line 11 through 15 does 2 different things. It talks about the operating budget not being more than the average cost to operate a similar juvenile facility in New England, and that biannually that be reviewed. With the lowest census in the country, with the highest need kids, We are not running the average facility of anybody else. We're running a much different facility than everybody else. So having us try to have an operational budget consistent with averages of any region or anything doesn't make any sense. I know there was a report handed out at a committee meeting that I wasn't at that was talking about the cost of incarcerating children per child. If you review that and you were to compare the other report that I shared about detention and commitment rates, you would see that the states that have the lowest cost per child also lock up the most kids. What that really is, it's a list of who locks up the most kids and how that's the cheapest way to run your system. And I personally can't be part of a system that's the goal of. And I don't think many of us want to be part of a system for which that's the goal. So I think we need to be really, really thoughtful and careful about things that would limit the operating costs, not based on the needs of the kids that we serve or based on the needs of the communities, but rather based on some type of average of a facility that is nothing like the type of thing that we're doing in New Hampshire, because we are so far ahead of the curve that you can't compare us to the balance of the curve. Page 5, paragraph or section 7, 16 through 24. I'm not generally opposed to this. What this talks about is the requirements of the director of the facility. Our last facility director retired in January. It took us till August to replace that person. And the main reason why it took so long is that we wanted somebody that met these criteria, that they actually had an advanced degree, that they were actually a licensed clinician, that they actually did all that work. So we did fill that position. This is in line with the person that's currently running the facility and who I think is doing an amazing job. And it's in line with what I would hope going forward. I would just caution that when you put these types of things in statute, it does tie hands, and who knows years from now whether we're going to have a hard time finding somebody with those qualifications. Again, I don't really oppose it because it's exactly what we've looked for and exactly what I think we'll continue to look for. But you're tying the hands of future people that might have to make decisions in scarcity. And that's a tough thing. I'd point to the example of our colleagues down in Rhode Island who have been out without a permanent child welfare director for almost 4 years now because there's requires that it be a master's prepared social worker, and they've been unable to find a master's prepared social worker willing to step into that job. Now, the biggest concerns that we heard most about have to do with these next few sections, section 8 and 9, which start on page 5, line 24, and go through page
I guess you're
7.
referring to a different amendment?
Oh, I'm sorry. Am I looking at the?
I think he just meant line 25, not 24.
I'm sorry. Yes, that's correct. Page 5. Yeah, page 5, line 25 through, and I am working on a printout that I got before this morning, so it is slightly different. Through page 7, 21. So this is what's been referred to as the HB 254 language. So a couple things that I think the committee needs to understand. One, I do think it would be helpful to have, the other committees look at this who go deeper into this work on a regular basis. But moreover, this language talks about commitment, right? And we've had this conversation before, but commitment refers to the time at which we're making a decision that a child needs to be placed after you've adjudicated them. But other parts of the law disallow you to also detain a young person. That's temporary, immediate detention for things that are not committable, right? So even though this talks about commitment, it equally applies to detention. The big change here is if you flip to page 6, I'm not so concerned with the first part of this because the second part is where most of this would come in. So that's section 9. So currently, very, very few kids get detained or committed at SYSC. The reasons for that, like I said, system of care, the law change. Also, though, this document, which I'm happy to share and walk people through. Thank you. That is the detention assessment and screening tool, which is a court form which was put together by people who actually work with kids in these situations on a regular basis, right? Public defenders, prosecutors, probation officers, clinicians, judges. They put this together to help them guide the decision as to who gets detained or committed. I heard comments when I shared the data in the past about how you saw the commitment levels drop so radically, but detention levels really didn't move that radically. That's because they were using this for years before the change in the law. That's what drove detention levels down. And it was done not just because of the change in the law, but because the people who do the work cared to try to get that done. And what this sets up is different types of offenses. And you can see that on the back couple pages here. And it sets up different scores for different types of offenses as to when they'd be eligible for detention or commitment. Really, this is just for detention, not for commitment. Level 4 offenses are similar to the things that are listed in the statute, right? Murder, stuff like that, absolutely. Level 3 offenses, a little less severe, typical felonies though. Level 2 offenses are things like Class A misdemeanors, things like simple assault, domestic violence, and yes, as Representative Hull said, stealing an iPad could be a Class A misdemeanor, but that is not the extent of what consists of Class A misdemeanors. And I have never seen in 5 years a kid go to SYSC because they stole an iPad. That's not why they go there. They go there because there's issues of violence in the home, violence somewhere in the community, and this tool is what's guiding that. So, if you look at the back few pages of this, it has a list of all the criminal offenses, and it gives them a level score. You would notice on here that simple assault and domestic violence are only a level 2 out of 4. If you go back to the first page here, you'll see that a level 2 offense only gets 4 points. The way that this process works, you need to get 12 points to be recommended for detention. So typically a simple assault or domestic violence Class A misdemeanor is not going to get you detained or committed. But what the rest of this tool does is it goes through the more nuanced things that a judge has to think through when measuring community safety and risk to the child themselves. Things like what other charges are currently pending or have been recently disposed of? Has this child recently absconded or run away? Things like, there's also things that reduce the score, right? If the kid's got, a safe place to return to. And this allows a judge to actually make a nuanced decision about whether it's appropriate to detain or commit a kid. And I would say the evidence that this is working is the fact that we have the lowest rate of detained kids in the country. There is one state that has a lower detained alone than us. That's Maine. They report 0. I believe that that's inaccurate. I think it's a semantical issue because they call detention shock commitment. So their commitment numbers are really high. Their detention numbers are 0. If you exclude that, we have the lowest level of detained kids in the entire country, not just detained and committed combined, but detained. And that's because we're really good at trying to be careful not to use this where we don't need to use it. So I am really worried about these changes in Section 9 because where you put a Class A misdemeanor as only being eligible for detention where there are 3 prior defenses within the past 12 months, there is a potential for a situation where you have a young person who maybe committed an act of domestic violence and is not safe to return home because of that, but it cannot be elevated to a felony level because of the severity of the injury. The biggest difference between kind of a simple assault and an aggravated assault or assault 2 is the severity of the injury. It's not really about the incident or what the kid did. It's about how bad was the other person hurt, right? And that really isn't the measure, I think, that should be kind of the end all be all of the consideration of whether a kid is safe to return home or safe to go somewhere else. It needs to be more nuanced in the way that the courts and the people who do this work have already thought through very thoroughly. Moreover than that, though, this change will not meaningfully impact the census of SYSC. There are almost no kids that get detained for a single simple assault or a single domestic violence charge. Overwhelmingly, those kids are already going to residential settings. But the fact that that safety valve exists within the system allows law enforcement and prosecutors to feel comfortable deferring bringing charges against kids. So you heard a bit of a conversation with Representative Lynn about concerns that you could see prosecutors or judges upcharging kids, or more significant than that, what I'm more worried about is you see prosecutors being less willing to defer bringing charges at all because they're going to feel like they need to get their 3 priors to make sure that that kid's eligible for SYSC. And doing this now, when we're just in the midst of implementing what I think is a revolutionary change in the way that we make these decisions for kids, would be terrible. We just passed SB 94 about a year or so ago. We've been implementing it for a year now. What SB 94 does is every time law enforcement has contact with a kid, They come to us, we do a child adolescent needs and strengths tool assessment, and then we make a recommendation back to law enforcement. Is this a kid that needs to go to court, or is this a kid that we can use one of our many community options instead? 72% of the time, we're saying this kid shouldn't go to court. You shouldn't even bring this kid to court in the first place. This kid should go to a community-based service and totally avoid the juvenile justice system. 94% of the time, law enforcement is agreeing with us. That's under the current system where they know they have that safety valve if they really need it. If we were to change the dynamics here, I very much worry that you're going to find law enforcement being really reluctant to defer filing cases against kids, because instead of knowing that they have a safety valve just in case things get too heavy and there's an incident of violence that they need to respond to, they're going to be thinking, I need to get 3 strikes or else I'm not going to have that safety valve in place. And at the time when we're really seeing radical change in our system as a result of the implementation of SB 94, I think that would be devastating. I think we would see all the progress that we've seen over the past couple of years start to erode, because you would have law enforcement not trusting the ability of the system to respond to community safety when necessary. And again, it almost never happens. I hear of it happening 1 or 2 times a year of a kid who has less than 3 priors. But when it happens, it's typically short-term detention. It's typically to try to make sure that the family is safe and that you have a safe place to have that kid go. And then within a couple days, you're able to work it out where either the kid's able to safely return home or go to another family member or anything else. The other thing that impacts this is that there's no ability in our system to temporarily hold a child anywhere other than detaining them at SYSC, right? You can't temporarily hold a child in an adult municipal facility. The laws around that are that kids can only stay there for a matter of a couple hours for processing and then need to move to SYSC. So if you take this tool away, you don't even have the opportunity to kind of let somebody cool their heels at the county or at the local jail while you're working things out. You just take that totally away from the system. And then I have a couple other things that I would just point to. I'm okay with the changes that start on page 7 regarding trauma-informed care. That's fine with me. If this was to go forward, I do think there's an error in the applicability, at least on the version that I was working on. Let me double check if it's the same in this version. Yeah, so page 8, line 1 talks about sections 7 and 8. Applying to cases where a dispositional order has not yet been ordered. Section 7 was about the qualifications of the SYSC director, so I don't think that's what the intent was. I think the intent was for that to be 8 and 9, not 7 and 8. And with that, I am happy to take any questions.
Thank you. Any questions from the committee for the director? Representative Nordgren, come to you next.
Thank you, Mr. Chair. Thank you, Commissioner. You've given us a lot of information. Do you think you could maybe write us a memo that includes all the questions and comments you had?
I could.
But-
I'm very busy and
Okay.
and it will take me a minute, but if that's something that the committee would like, I could do that.
I didn't hear the question, Mr. Chair.
I was wondering if maybe we could ask him to give us some sort of a summary of all the comments he's made and all the corrections and ideas he had for changes in the bill. I think they're significant and helpful. Thank you.
I'm also happy to, if there's a work session where folks want to go through this, I'm happy to sit through that too, if that's helpful.
Representative Edwards for a question.
Thank you, Mr. Chair. I'm looking at the handout that you gave us on the State of New Hampshire Judicial Branch, the multi-page document, where I don't see a page number, but it headlines Detention Assessment Screening Instrument Instructions. There's RSAs cited. There are specific offenses cited. I see crime levels. Those all look like criminal code issues to me. So my question is that since we formed a new general court in January of 23, just a few weeks ago, bills in this area have been heard and voted out 24-0 by the Senate. Children and Family Law have looked at a similar bill that they've retained because they think they want to be able to work on it. Division 3 Finance has worked on it. Is this the first time in this legislative session that you've seen a specific amendment or discussion related to changing the criminal offenses for which a juvenile could be detained or committed?
Yes.
Thank you.
Further questions from committee members? Representative Sweeney.
Thank you, Mr. Chairman. Thank you, Commissioner, for being here. So this form that the judicial branch uses, is it spelled out in statute for the judges to use this form, or is this a practice that they've adopted that they could change?
So it's not spelled out in statute, but the courts instruct their judges that they have to use these forms when they're doing these things. And this was originally written, I don't know, 10 or so years ago, and then it was updated with the law changes that occurred whenever that was, 2018-ish. To that, so you see that kind of section B here. That's to incorporate the stuff from 2018 that occurred. So it's consistent with the law, but the law doesn't specifically require that the form be used.
Thank you very much.
Further questions from committee members? Seeing none. Thank you, Director. And we'll look forward to you at work sessions.
Mr. Chair, can Mr. Ribson stick around for Representative Lynn's introduction of his amendment?
He affirms that.
Thank you, sir.
I will next call Cody Belanger.
I'm sorry, can you hear me now? Good morning, Mr. Chairman and honorable members of the committee. My name is Cody Belanger. I'm from Epping, former member of the past legislative session. If you remember, I stood before our session and told you that I have personal experience if you were here to last session. I'm also the chair of the Juvenile Justice Reform Commission, which is recently reestablished by the governor about a year and a half ago. I'm tired of watching this get punted back and forth. I look at the bills, I pay attention, and what I see is very similar to Washington, D.C. It's not a clean bill. The amendment, trash. New Hampshire has been looked at as an opportunity to build a state-of-the-art facility. A facility, not policy. We're getting there. Through diversion programs that have been established over the years, we have seen a decline in committed youth. We have what? What's the census today? 10 students, or juvenile offenders, if you will. When I was there, full. Waiting list to get into group homes. You see the advocates behind me. They've all told you we want a facility, a new facility, one that's home base, not prison base. We had a work session in my first term for the summer where we heard so many solutions brought before us. Someone had the audacity to recommend that we build a wing on a county jail. How depressed do you think that student or juvenile offender would be if he rolls up to Rockingham County Jail and sees all the barbed wire, men in jumpsuits? Not very. Be very depressed. The opportunity that's before you is to build a facility. Take policy out of it. Put the policy into a separate bill. Clean it up. 18 beds. We've seen the numbers. That's what supports. We had a whole 2 years when I was in the legislature in an attempt to do this right. And here we are again. in the first year of the first session, not even close. Senate Bill 93 or 98, Director, last year? Excuse me. Senate Bill 94. What it did is essentially provide a diversion to prevent kids from even being arrested. And we're not talking about the habitual offenders, the 10 out of 10 offenders. We're talking about the kids with low-level crime. We're New Hampshire, a population of almost 4 million people. We don't have very many high-risk offenders. We don't get very many young murderers. They happen, and it's unfortunate. But you can't just go to zero. You'll never be able to do that. We'll never be able to completely wipe out not having a facility, which has been floated. So then what? You're going to send these kids to Massachusetts, Illinois, Tennessee? What about moms and dads, family members? Article after article after article has proven that kids are successful if only one adult shows that they care about these kids. I am living proof that that can happen. I've sat on the other side of this table because one person cared about me enough and told me that they loved me when I thought the end was never going to happen. Now, of course, some of you might be thinking, I'm not going to listen to this guy. He didn't win. He's just on his soapbox. Maybe somebody on the other side of the screen watching of the other 400. But the opportunity to build a facility that fits the need of the system of care that we've been building for years, even before I became a legislator, when I was an advocate. We have the ability to do that. What we need to focus on, what I believe should be the focus, is the building and what goes on and how it's built, not what goes on the inside. That should not be the focus. That can be a focus for the second part of the session. But the main focus should be the studs, the brick, and the mortar. Thank you, Mr. Chairman and honorable members of the committee, and I'm happy to take any questions.
Thank you. Any questions from committee members? Representative Edwards.
Thank you, Mr. Chair, and thank you, Honorable Belanger. Hey, I think I heard you essentially testify that you're opposed to 0767. And if I heard you right, as a former state representative, do you think that perhaps this bill should be redirected over to Children and Family Law so that they can consider it as the policy committee?
Thank you, Representative Edwards, for the question. As a former member of that committee, I do believe that if this is policy, that's where that bill should be directed to. Yes.
Thank you.
Any further questions from committee members? Seeing none. Thank you, Cody. Other interested people, I have 7 cards before me, people wishing to testify. We've gone fairly long on many of these people testifying, so if there's something that's mostly been said, and I see the majority of you are opposed to the bill, if you could just not repeat any of the testimony we've heard, but give your personal reasons why you oppose the bill, I would appreciate it.
Hey, may I ask for a clarification, sir? You're saying they're opposed to the bill or they're opposed to this amendment? I just want to be clear.
All I have is what's checked on the pink card.
Thank you, sir.
I'll next call Karen Rosenberg.
Good morning, members of the committee. I'm Karen Rosenberg. I'm the policy director at the Disability Rights Center. I'm here on behalf of the Disability Rights Center as well as on behalf of the Juvenile Reform Policy Group, which is an advocacy group comprised of Disability Rights Center, New Hampshire Legal Assistance, the ACLU of New Hampshire, oh my goodness, I'm going to forget, Waypoint, New Futures, and the Children's Law Center of New Hampshire. And those pink cards are challenging. So and if you don't color well inside the lines. So the position that we're taking is this. We fully support the development of a replacement facility for the Sununu Center. However, we have issues with the amendment that's under consideration right now and concerns about those. And that's what we will highlight. So I will limit my testimony to a few of those issues, and then one of my colleagues who is much more familiar with the juvenile sentencing provisions will address those. And I'll do my best to keep it short. So with that clarification, the provision that I believe Director Ibsen did address has to do with staff ratio. It's section 2, Roman 3, small letter J. It's on page 24. So as the director explained to you, there really aren't a lot of standards or accreditation for juvenile justice facilities. And what we look to are things like the Prison Rape Elimination Act, or PREA, which calls for a 1-to-8 ratio. And I understand, the way I look at this provision, perhaps it's an effort to be in line with this committee's responsibility, spending state dollars responsibly. But I also think the committee needs to invest New Hampshire dollars responsibly and with an eye towards how we can do that in a way that will ensure good outcomes, the best outcomes for kids who are really vulnerable. And in our state, with so few children who are in this system eligible for commitment, that will do it in a way that these children will come out better than when they went in. So, we are not a state that subjects kids to secure confinement when they shoplift, graffiti, do minor crimes. Like, we're talking about some pretty serious offenses that are causing kids to be ordered to Sununu Center, and there aren't very many of them. So when we're looking at economies of scale here, and what's required for these children, they're gonna need adequate staff because these are children with very serious emotional issues, very serious trauma, and behavioral challenges that are difficult to manage. What I think is that the only way that this really small population of really high and challenging children could be addressed with a ratio of like 1-to-8 would be essentially to keep kids locked in their rooms, because otherwise you're going to have kids and staff in unsafe situations. That's like putting kids into solitary confinement. That's not therapeutic. That's counter-therapeutic. It's not what the goal is here. The goal is to provide a therapeutic, evidence-based, trauma-informed treatment center for these kiddos. And room confinement to keep them safe because we don't have adequate staff to supervise and engage with them just shouldn't be an option for this committee. The provision I don't really understand is the following one, letter K, the strategic downsizing considerations. I'm baffled by why it's there. As I understand what this Council on Juvenile Corrections Administrators did was they helped develop a format for states that have multiple facilities to consider how they can shut down facilities. I didn't read the information I was able to find online to suggest that it would be for the closure of all facilities in a state. And I think that the Alvarez and Marsal report, all the community meetings that took place really were in keeping with a lot of the recommendations. So I guess I don't understand why it's there. The next section that I want to address is the operating budget. I mean, similarly to what my first point, I think what we're talking about here is, yes, we have an obligation to spend state dollars responsibly, but we also need to invest them responsibly. And staffing and numbers of children go hand in hand. The provision requires a budget that is things commensurate with the average cost per child to operate a similar juvenile justice facility in New England. There aren't any. There just aren't. So our goal is to do something different. And the operating budget, the per child operating budget is going to be higher than it is to operate a juvenile jail, essentially, where you're housing 40, 50, 80, 100 children. So when we're talking about 12 children, it is going to cost more. I mean, there's no way to hide that. But we've got to keep the needs of our children front and center here. Their treatment and safety needs, and the goal that when they leave this facility, they'll be better off than when they went in. So it is going to be more expensive to have an adequate operating budget for students and children in a facility that promotes healing and evidence-based care while simultaneously protecting the security and safety of our communities. And that's going to be much more expensive than warehousing children in a juvenile justice facility that houses many more lower level offenders. So for all these reasons, the testimony you heard from Director Ripson in particular, I ask that you vote against this proposed amendment and that you support something more along the lines of what Representative Edwards had put forward in his amendment. And I'll take any questions you might have.
Thank you. Any questions from committee members? Seeing none, thank you for your testimony.
Thank you.
We'll next call on Susan Stearns.
Good morning still. For the record, my name is Susan Stearns. I'm the Executive Director of NAMI New Hampshire, the National Alliance on Mental Illness. The testimony that's being passed around was actually written by our Director of Public Policy, Holly Stevens, who is literally digging her way out of her home still and unable to be here today. So NAMI New Hampshire is a grassroots organization working to improve the lives of all people impacted by mental illness and suicide through support, education, advocacy. While we applaud the work of this committee, and I actually feel privileged to have been in the room today to hear the discussion and recognize how New Hampshire is such a leader in this field. I'm grateful for that opportunity. We do oppose this amendment, and I won't go into detail. You have heard clearly the concerns around sufficient funds for the staffing ratio, as well as ensuring that the treatment does meet the needs of these high-need children. I will say we know that many of these children have mental health challenges, and we know that statistically children with mental health challenges are far more likely to wind up in our adult criminal justice system. So investment here and now for these kiddos will ultimately save us money long-term as well as probably lead to much better outcomes for most of them. I'm happy to take any questions, although I really wish Holly were here to respond to them.
Thank you for your brevity. Questions from the committee members? Seeing none, thank you for your testimony.
Thank you.
Well, let's next call on Renee Toohey Childress.
Good morning, thank you. So this is actually going to be quick because what I prepared was kind of covered by everyone. So, but I wanted to
Thank you for recognizing.
Yes, I wanted to kind of give a practical opposition, if you will. So I am the executive director of Dover Children's Home. I also sit on the Juvenile Justice Reform Commission. So we run a level 2 residential treatment program, which essentially is community-based. So our kids go to school in the community, they work in the community, and they live in a home-based environment. We run our program restraint and seclusion free, and we have for 17 years. However, we are able to do that because we run our program on a ratio of 1 to 3. What this is asking for is a ratio of 1 to 8 if we line it up with PREA standards, which is completely inappropriate, unsafe, and absolutely will never meet the treatment needs of youth. That's all I have to say.
Thank you. Questions from any committee member? Seeing none, thank you. We'll next call on Michelle Wangerin.
Good morning, Honorable Chair and members of the committee. My name is Michelle Wangren. I'm the Youth Law Project Director at New Hampshire Legal Assistance, and I'm also here testifying on behalf of the Juvenile Reform Policy Group, as my colleague Karen Rosenberg previously mentioned. So I'm going to focus my testimony today on the HB 254 amendments. So that would be Section 8 and 9 of the bill. And I've been involved in this project before it became coupled with redeveloping the Sununu Center. This was a standalone bill several years ago and has been through the policy committee several times. Well, I think that this is an improvement to some of those earlier versions of the bill, which were very confusing. I continue to have some major concerns about both the bill itself and also the need for the bill. So, first of all, I think that this needs to be done separate from redevelopment of the Sununu Center. And the reason for that is because it doesn't actually affect the census of the Sununu Center, as you heard from Director Ribsam. There may be one or two kids that it could impact, but the reality is that the way it's morphed over time is that although the initial provisions of the bill try to limit the door to serious violent crime, there are enough catch-alls now in this version of the bill that my perception is that it's a net zero. It doesn't actually do anything. So what that leads me to do is if we're writing legislation that does nothing, we have to be concerned about what harm it will do. And what we just heard from Director Ribsam is very concerning. There has been great work with SB 94. The front door has been narrowed to the Sununu Center in recent years, not because of closing off the offenses, but because we have prioritized diversion. And that is a very real policy goal that has had very real impact. If we want to further narrow the door, I don't think the right way to do that is by closing the door, but by building up the system of care. Those kids who are first-time offenders committing domestic violence offenses at home, either against their parents or their siblings, we need to build up the system of care to be able to manage those kids in the community. If they are low-level offenders, we shouldn't just say, well, you're not welcome at the Sununu Center because you have to go somewhere else, but where else do we send them? Or better, what services do we provide to them? Are we sure that there's mobile crisis services that are effective enough to deal with that situation? If not, let's look at that. Because the reality is that when kids are determined to need commitment and the door is closed to them, they don't go home. They don't go to the community-based services, or the judges would be ordering those community-based services. Instead, where they go are out-of-state facilities like Mill Creek, and Mill Creek in Arkansas. And when you look at Mill Creek's website, they bill themselves as a long-term, and we're talking like 9 to 18 months, long-term treatment facility for out-of-state students or out-of-state youth. Not even their own youth, but out-of-state youth. Why are we sending kids to an out-of-state facility that welcomes in out-of-state youth to provide long-term treatment to them? That's not who we are as a state. That's not where we're going as a state. And so rather than looking at, can we stop two kids from going to the Sununu Center and risk completely upending HB or SB 94, let's look at doing something meaningful to these kids in the policy group where I think that bill belongs and where that work belongs. So all of this to say is that I am here strongly in support of Amendment 804H and strongly against 767H for all of the reasons that you've heard today. I'm happy to take any questions.
Thank you. Any questions from committee members? Seeing none. We will next call on Cassandra Sanchez, Office of Child Advocate.
Good morning, committee members, and thank you for your time today. I will share that I will keep it extremely brief. Many of my colleagues before me did share many of the concerns that I have here. I'm just going to focus, as my role as a child advocate for the state is the best interest of these children and keeping our children in New Hampshire. So what I will share with you is my concern for the statement around ratio of the children and staff in the facility. I will share I had an opportunity to go out to Arkansas over the summer, and I had an opportunity to experience their treatment center where they house over 100 youth in one center. And in that says their juvenile detention center. And in their juvenile detention center, they had very low staff ratios. And at the time that I was visiting one of the cottages, they had a ratio of 2 staff to 12 children. And what that resulted in was what they called a cottage system. And what that means is that half of the children were in their rooms for half of the day, while the other children could move about the cottage. Then they would take turns switching. The other half would be released. They would move about the cottage. The other half would remain in their rooms for that time period. And the time that I was there, because there were additional adults in the room, they were allowed to let the children out. And so we had an opportunity to speak with the children in groups. And what they shared was how that felt for them to be trapped. They shared the experience of feeling like animals all day long, and that they did not have any dignity and respect because they were held in their rooms because staffing did not allow for any changes. And I was there with an advocate from Arkansas who was working diligently to remove that cottage system for these kids because she recognized how damaging that system was. I do not want to see us join in Arkansas and treat the children of New Hampshire in that same way. Our children deserve much more dignity and respect, and what they truly deserve is treatment. We understand these are children with extremely high needs, and to be able to deliver trauma-informed care and utilize the therapeutic approaches that we would like to see in the Sununu Center, we need a new facility that the building space is trauma-informed and that the ratios are similar to what we just heard from Dover Children's Home, the therapeutic approach. We need to be looking at this new facility and comparing it closer to what our residential facilities look like, because those are the areas in the state where our children get treatment. They have the ability to make the necessary changes to be successful and safe in the community, and then they have those opportunities to return to the community and be successful. We have seen that work for our children, and so we need to look for that for the new facility. I will also share, in my time in Arkansas, I had an opportunity to visit Mill Creek in Arkansas. I did visit that residential facility and met with the children from New Hampshire that reside there. And I understand, as a state of New Hampshire, we send many children there. What I will say is that is a practice that I would like to see us be able to scale back on. And in doing that, we need to ensure that we have the appropriate treatment available here. We are doing that through building out the children's system of care. We need to continue to pour our money and our efforts into that community-based system so that we can keep our children here and in programs or in the community in New Hampshire. It is quite unfortunate to see that we are sending children to a facility where their own state will not send their children there. Although they are licensed, they will not send their children there because they hold concerns for them. And so realistically, we want to ensure that even our children in the juvenile justice system, we want to keep them here to get treatment here. So in the long run, as they moved into adulthood, they're not costing the system more money on the other end. When children don't have the opportunity to get the appropriate treatment and reform, we see them costing more money in the adult system. And although it is a lot of money we're asking up front now to invest in our children, we believe that the long run outcome will be worth it. Thank you.
Thank you. Can you give us a number of New Hampshire children and why they were sent there? Was it the court or was it some other function?
I don't have the exact number for today. When I visited, there were 4 children there. We do have times where there's more or less children at the facility. Some have been sent there because their needs could not be met at a residential facility in the state of New Hampshire. With building out the children's system of care, as well as investing in Hampstead Hospital and a level 5 PRTF to be built at that facility, that can resolve some of this issue in sending children to out of state. But that a lot of it is that their needs could not be met at the level of programming here.
So this was less confining than if we'd sent them to the Sununu Center.
Some of the children that I do understand that have gone to Mill Creek were eligible for the Sununu Center, but ultimately they were able to, with great advocacy on their end, were able to go the route of placement in a residential facility as opposed to Sununu Center. in the future, if we are struggling with said youth and they have that level of charges, and we know that Sununu, the new replacement facility is a treatment facility where they're getting adequate care and they have that option, or to go out of state, the advocacy may be otherwise. The attorneys that are supporting these youth may advocate for them to stay at Sununu knowing that they're getting the treatment that they need. And that's one of the reasons why we need to have the facility that has that approach in this state.
Thank you. Questions from committee members. Representative Edwards and Representative Bucco.
Thank you, Mr. Chair. I just to let you know, I think I have 3 questions that may require a paragraph answer or so. Sorry. Because she's the state's child advocate, I just want to make sure I'm clear on a few points. There are experienced senior legislators who have proposed that if we do not have the capacity at our new facility, that we ought to just be prepared to send juveniles out of state. What do you think our position as a state ought to be on the option of removing our citizens to another state for confinement?
I think it's quite concerning to consider out of state the option, the solution. As you heard before me, some were speaking about families. These children have families. They have connections to this state. They have friendships. They have other motivators to stay on track and to do the right thing. And if we keep them in their community close to those motivators, then they have the success to return back to their communities and to their home settings.
Follow-up.
So thank you, Mr. Chair. And similarly, I've heard from many of those same senior folks that that if we have a capacity issue at the new facility and we end up with additional placements that need to be made, that what that ought to do is trigger sort of a mandatory release of a resident prior to them having completed their treatment. What do you think the appropriate state position ought to be relative to an artificially early pre-treatment release of a resident who is otherwise supposed to be at this facility?
I do believe those administrative releases need to consider the clinical impact. There is a great clinical team that exists in the current facility, and there may be times where an administrative release is a conversation, but they have a seat at that table to say what needs to be in place for that youth to be successful. So there may be times where the youth may not be have completed their treatment at the facility, but there may be adequate treatment options in the community that they can transition to. As long as that is being explored and the clinical lens is part of that conversation, then that could be reasonable. But if it's administrative release only for capacity and not taking into account that child's needs and treatment needs, then that could create a problem, because that could be a youth that's released too early and will end up right back in the system.
Follow-up.
Okay, and I've also sort of, in previous hearings, heard people bring up the horrible history of the Sununu Center relative to the abuse of kids, and the basic question, why would, insanity is doing the same thing over and expecting a different result. Well, is it your understanding that what we're proposing with these other amendments is something fundamentally different than what we've done historically in terms of providing for the issues related to these kids?
Absolutely. That's where the therapeutic trauma-informed care comes in. That is fundamentally different than the way in which the facility was operated in the past. It takes skilled staff who understand what these children have experienced in their lives prior to getting to the setting to be able to engage in that trauma-informed care. And so if we're looking for more skilled staff, hopefully salaries that match that skill level, will be getting staff that can adequately meet these children's needs, not staff who are frustrated and burnt out within their positions and don't have the ability to deal with some of the difficulties that come with managing their trauma in this setting and settling into an institutional-like setting. So I do believe we have that in place. We also have the Office of the Child Advocate, which did not exist at that time. And my office receives in real time any restraint and seclusion that's occurring, or any incidents in general that occur at the facility. And so we're able to look at those in real time as they come in, assess what has happened, and any concerns that we see within the facility, within specific staff or specific children, the ways in which they're responding to those children, we can intervene early on before it gets too far.
Thank you, Mr. Chair, and thank you, Ms. Sanchez.
Thank you.
Representative Bucco for a question.
Thank you, Mr. Chairman. Thank you, Advocate Sanchez. This Arkansas facility with the cottage facility, is this a for-profit facility? 'Cause
Yes,
that's
it
what
is.
it sounds like.
Yes.
Thank you. I think I should
Follow up.
follow up on that. Is a for-profit facility, would that be adequate for the type of inmates or people that need to be in this facility?
I don't believe for-profit should be an option on the table when we're looking at a replacement for the current SYSC. I believe it needs to be state-run. It allows the level of oversight that we currently have in the facility to ensure safety of the children, and it also allows for some of those shared services, as you have heard from Director Ribsum, and sharing services with a facility like Hampstead Hospital or the hospital in Concord. So with the shared services as well as the skill and ability of the staff differs when you take a look at private versus for-profit. So I don't even believe that that's something we should be bringing forward in this discussion.
Thank you.
Further questions from committee members? Seeing none, thank you very much.
Thank you.
I'll next call on John DeJoy. Welcome.
Thank you, Mr. Chairman, members of the committee. For the record, my name is John DeJoy. I rise in full support of this important amendment before you. As I'm sitting listening to the testimony today, I remember Yogi Berra. And I remember Yogi Berra because this really does feel like deja vu all over again. I've been working on this issue for more than a decade, and I'm very proud of the work that I've done. Much of it with my former colleagues who you've heard testify against this amendment today. But I think it's important that we shouldn't make a decision because we're frustrated. We shouldn't make a decision because we don't know what else to do. This is a decision that affects the lives of currently 12 children. Now, admittedly, it's a low number. It may be the lowest in the country, but I think that's irrelevant for this discussion because we're still talking about the lives of 12 children. And the decisions you make today will affect their lives. This is very much a financial bill, even with the policy implications, because the policy implications go directly to the census of the facility. You've heard people testify that the sections that are known as House Bill 254 would have no impact on the census. I disagree with that. And I will tell you if I'm wrong, 2 years from now, I'll stand up here and testify that I was wrong. I don't believe I am. This is not, nor ever has been, about a building. But most of the discussion over the last decade and in the last 2 years has focused on what the building's going to look like, how big the building's going to be, how many beds there are. And we have very little conversation, there has been some today, but very little conversation about the treatment children need. That is and always should be our focus. What is in the best interest of these kids? And I can tell you, incarcerating children is not in their best interest. We know that because research tells us that. We also know that the legislature understands that because throughout the statutes, it says repeatedly, least restrictive alternative. Children should not be incarcerated unless it is the least restrictive alternative. But we've heard today lots of reasons why children should be incarcerated that are not least restrictive alternative. I want to share some data that I've just tried to decide whether I should share it or not. This is data from the department, and I'm sure the department can get you the full report from 2021. Let's understand who these children are, okay? We know from past testimony from the department that maybe 75%, it's not my number, of the children have behavioral health needs. Many children have learning disabilities. Many children live in poverty or are homeless. What we've never talked about beyond that, who these kids are. Well, the report from the department indicates that many of these children are children of color. And I'm referring to the department's data. I just printed out a few pages, which I can share. I'd recommend you get this from the department, not from me. But this looks at calendar year 2017, 18, and 19 regarding juvenile justice. And in 2019, 17% of all arrests referred to the court were children of color. In that year, children of color represented 13% of the entire child population. That's a little bit higher. But when you look at kids referred for secure detention, it goes up. %40 of the kids referred for secure, 37.9% of the kids referred for secure detention are children of color. But yet they represent a quarter of that. And 49.3% of all children committed to the Sununu Youth Services Center are children of color. We believe there is a policy disagreement that is affecting the budgeting and the size of this facility going forward. We believe that children who are incarcerated at Sununu Youth Services Center or the replacement facility should be kids who commit or are charged with serious violent offenses. We believe the system of care exists to treat the remainder of the children who do not commit serious violent offenses. I have always argued to close the Sununu Youth Services Center, lock it up, and throw away the key. Through this process over the last several years, it has become clear that there will be a small fraction of children who we need to have the ability to incarcerate because of public safety or the perception of public safety. But contrary to Representative Lynn, I do not consider property crime to be a serious violent offense. I consider it to be an offense. I consider it something the child should be held accountable for. And I consider it something that the child should pay compensation or provide service for. I don't believe the child belongs in Sununu Youth Services Center or any other incarcerated setting. We talk about trauma-informed care, there's universal agreement that is the approach. Trauma-informed care begins with the culture of the facility. When you folks 2 decades ago decided to build the Sununu Youth Services Center, part of the reason was that YDC was having significant issues with allegations of abuse. Also had a very high recidivism rate. You folks decided to build the Sununu Youth Services Center, which you were assured at the time by the people who aren't here today, that the treatment would be better at the Sununu Youth Services Center. And we picked up YDC and moved it to SYSC. And we had the same issues at SYSC as we had at YDC. I believe the number today is more than 1,000 children have alleged sexual or physical abuse at YDC and or SYSC. You have a generational decision before you. Once this is decided, we won't revisit this for at least a decade and probably 2. You have the opportunity to take steps to make sure that the facility that replaces this, whether it's today, tomorrow, or next year, is an optimal treatment facility for children. That's what this amendment does. It adds pieces that prevents children who don't commit serious violent offenses from being incarcerated or detained, and adds pieces to explain what trauma-informed care is and to try to put safeguards in place to make sure that trauma-informed care is actually what is delivered. I can go through the 254 pieces line by line if anyone would like me to. I've done that before this committee a couple times in the past. Some of you weren't here. Many of you were. I will remind the committee, this was part of the budget 2 years ago, when you all had the courage to set a closure date for SYSC. Now, we had to push out the closure date, but the only reason we're here having this conversation is because you had the courage to do that. I'm asking you to have the courage to continue disagreeing with the Senate, to move forward with what is truly going to help children, and worry less about what the facility looks like and what the treatment delivered inside the facility consists of. We think this amendment does that, and I would ask you to support the amendment. I would say Representative Rice wanted to be here. She was unable to be here because she's still stuck in her driveway. She did submit testimony electronically and has asked that folks take a look at it. I could keep going, Mr. Chairman. I won't, but there were a lot of things said previously that I normally would comment on. I think I'd like to focus my testimony as I have, that this is a generational decision, and it's in your hands. And I hope you'll support this amendment, which builds on the work of Representative Edwards in the Senate and adds important pieces to it to fully flesh out what this facility ought to operate like to best serve children.
Representative Petrie for a question.
Right. Thank you, Mr. Chairman. I just need to know who you represent, sir.
Funny question. Today, I represent myself.
Okay.
I've done this work over the last decade representing several clients. Today, I represent myself.
Right. I see the orange badge. That's why.
Yeah, I have other clients. I do not have a client that asked me to represent them on this issue.
Thank you very much.
Further questions from committee members? Representative Irv.
Thank you, Mr. Chair, and thank you for taking my questions. I just have two. Does this amendment take a position on sending children out of state?
Thank you for the question, Representative. In fact, nothing in this amendment specifies a particular standard for staffing, nor does it contemplate sending children out of state. We agree that sending children out of state is a last least alternative. And as I understand it, it's typically done today for unique types of treatment needs that the state does not have the ability to offer in state. I would say further that we actually looked at the PREA standards and rejected the PREA standards you've heard, the 1 to 8. We don't believe that's reasonable. So it was an intent, that statement was an intent to address what is seen as a bloated budget for this facility. If it's causing more confusion, by all means, remove it. However, it does not refer to the PREA standards.
All right, follow up, thank you. And are there non-detention facilities available in New Hampshire?
So the system of care, as I understand it, and I'm going to be speaking out of turn because this is not my expertise. Mr. Ribson can speak to this more expertly than I can. But the system of care provides a number of types and intensities of care. As I understand it, there are group homes, which go up to a level 4 type group home, which based on the contracts can deal with children who are adjudicated. So yeah, there are, and they're technically considered non-secure, I believe.
Thank you, Mr. Chair.
Further questions from the committee? Representative Edwards.
Thank you, Mr. Chair. Thank you for Mr. DeJoy for taking my question. It's my impression that one of the reasons that there hasn't been as much dialogue this term as opposed to previous terms, but in this term about the operations of the facility, is because there's just devastatingly broad consensus that we're trying to build an entirely new model here, a therapeutic model that's trauma-informed. And since there's not really been any disagreement on that, I don't think that there's been much discussion on it. The discussion for quite a while has been focused on something very specific. And my question to you is, the specific issue has been the maximum capacity of the facility. There were advocates for 6, then there were advocates for 12 with the potential of going up to 18 should a exigent reason exist. What is your position on the maximum capacity? Do you have a number that you would tell us?
Thank you for the question. And just to start, I reject the premise that there's broad consensus. There is broad consensus regarding trauma-informed care, and I can support that. You know, right after you folks set a closure date, I met with the commissioner and the director with a number of other advocates. And the commissioner asked me the very same question. How many beds do you want? My answer then is the same as it is now. The number of beds is irrelevant. It's the number of children who are incarcerated there that's relevant to me, and the treatment that those kids who are there receive. That's what's relevant.
Thank you, Mr. Chair.
Further questions from committee members? Seeing none, we'll next hear from the Honorable Neil Kirk.
Good morning, Mr. Chairman and members of the committee. For the record, I'm Neil Kirk. I live in Ware, and I'm representing myself. As others who have spoken, I've been involved with this issue for at least 8 years, and I can see it's finally coming to a conclusion, which is very pleasing. I support the amendment 767 because it's a comprehensive compromise that deals and resolves the Sununu issue, at least for the next decade. If you look at the co-sponsors and sponsors of this bill, you'll see that it is a broad group of people. These folks got together and they came up with a comprehensive solution. And what does that do? First of all, it builds the replacement facility, 12 to 18 beds, but staffed for 12. Appropriates $21.4 million to do this. Secondly, because we don't want to repeat the disastrous history of YDC and Sununu with respect to abuse situations, it puts in place a different philosophy, a different culture of how this operation is going to be run. You've heard it mentioned, trauma-informed care. The director is required to have certain criteria, and staff members are required to implement certain criteria so that the children will be receiving the care that they need here, and the staff will not be the kind of staff who staffed YDC and Sununu. It will be a different breed of person with different training. And that's very important. We don't want to repeat what's happened in the past 2 facilities. Thirdly, this amendment puts into effect what this House over years has decided is important, and it's been referred to in shorthand as House Bill 254. The offenses for which commitment, detention at Sununu are further limited. If you look at the charts that the department has presented, you'll see that the census at Sununu has dropped from 120 to 12 over the past 5-8 years. And that's largely, not exclusively, but largely because of the statutory changes. Because the philosophy of this House has been children should receive treatment in the community rather than in the facility. And it's only for the most dangerous children that the facility is appropriate. This comprehensive solution includes that, so there will be a further reduction, we believe, in the number of children who are committed or detained in the replacement facility. It's true that the current House has not acted on this. But if you look back at the years and the various Children and Youth Family Law Committee actions, you'll see that it's consistent in this area. Let's put only the most difficult children, violent children, into this kind of a secure facility. Fourthly, with respect to budgets, there's been some discussion today of those, and I think perhaps a reminder of how the budget process works would be helpful. There are some, let's call them guidelines about staffing using some sort of regional average and costs. Remember how, and I'm sorry to have to say this publicly, but I think some of the people who testified need to hear this. I'm sure you folks don't. One of the things when you put something in statute is that the department, when it prepares its budget, has to follow the statute. So this committee is going to get a budget for the replacement facility based on the criteria in this bill. It won't be PREA. That was a red herring. It will be whatever standards are used. Now, you've also heard some information which suggests these standards, the average, don't make sense. And guess what? That's the purpose of the Finance Committee. The department will come in and present a budget that represents what the statute requires. They will also, because this committee will ask them, certainly Division 3 will ask them, well, is this adequate? Do you need more? And then Director Ibsen or his replacement, if this happens in the future, will come before you and say, look, our facility has a relatively small number of children, and these children are much more in need of, or much more dangerous perhaps, than in other facilities. So our staffing ratios cannot be the average. And he will make his case. And you will evaluate that. So the actual budget is not going to be determined by the language here. This language only talks about what is presented to this committee, what the governor will present in his budget, what the department will present in its budget. But you will make the ultimate decision, and I'm quite sure it's going to reflect the reality that you can't have a very small number of staff members for these kinds of children in this kind of a facility. Bottom line, this bill, a comprehensive solution, gets the Sununu issue off the table and resolved. And for those folks like Representative Lynn who have a particular issue, or the department which has some concerns, as was mentioned, there is House Bill 120 where these issues can be worked out and any changes that that body feels are necessary made. It's important that we take a major step forward, not just simply put into place a building, but also the comprehensive part that is this 767. The issues that advocates and lobbyists raised can be handled in 120. But right now, you've got a very comprehensive package that deserves to go forward. There were some technical corrections, I understand, that need to be made. But beyond those, this is really a solid piece of legislation. Thank you, Mr. Chairman. I'd be pleased to answer any questions if there are any.
Thank you. Questions from the committee members? Representative McGuire.
Thank you, Mr. Chairman, and thank you, Mr. Kirk. I'm inclined to go along with your position, but I want to ask you about possible other sort of negative consequences of reducing the population even more severely than it's already been reduced. So in my mind, one of the reasons we have commitment or incarceration or whatever is a consideration for the victims of crimes, that we remove criminals from their presence so that they will not be further victimized. And is there any, do you think there's any concern here that by releasing or not committing juveniles who commit crimes, that we will expose the public to further crimes and further victimization. Thank you.
Thank you for that question, Representative McGuire. Obviously, that's a danger, but that's a danger at whatever level or whatever standards you use for commitment. I think that that would be an important factor taken into consideration when children are committed to the Sununu Center. But it is certainly a risk, and I don't think this bill or any bill is really going to be able to answer that. Unless you want to take the position, which I know you don't, and I certainly don't, that all children who commit just about any kind of inappropriate, abusive activity should go to some sort of facility like the Sununu Center, which had 144 beds at its maximum. And I think we've all agreed over the decades that that is not the right place for most of these children.
Further questions? Representative Edwards.
Thank you, Mr. Chair. I don't want to refer to it as 254 because that's a dead bill from a previous era. But I will refer to 0767 sections 8 and 9. I believe your testimony was that these items have not been heard yet anywhere in the Senate or in the House, and that this is the first time this topic has been introduced. Would you believe that both the current chairman and current vice chair, representing our two great parties, have both independently and collectively told me that they want, since they've retained HB 120, they want to bring sections 8 and 9 into their process because they're the policy committee and this is major policy. Would you believe, one, that they've told me that, and two, if you accept that, shouldn't we respect their opinion on what's in their jurisdiction and what is not?
Thank you for the question, Representative Edwards. I certainly accept your characterization. I have no reason to doubt it. But I would say this. While the legislature each year is new and each year can undo whatever has been done in the past, and there's no certainty in that, this House as a body does have a history, and the history is 254, which is my shorthand for sections 8 and 9. It's most appropriate for this body to recognize that history, include it in this bill, recognizing that there is another bill, House Bill 120, which is before that committee, which next year, and they've retained it, and which next year they can work on it. And if, in fact, they decide that these things need to be changed, and my guess is that because the House has been so consistent over the years in doing this, that they will make some slight tweaks, but not change the basic policy, that this body can go ahead with these sections in relative comfort that it is advancing the policy positions of this House and its Children and Family Law Committee over the years.
Thank you, Mr. Chair. Thank you for your answer.
Anything further from the committee? Representative Popovici Miller.
Thank you, Mr. Chair, and thank you for taking my question. We've listened to a lot of testimony, and personally, I'm really conflicted here because on one hand, this seems to be generally a good direction, but there have been a lot of concerns raised about the language and the possible side effects and undesired consequences of some of those, changes. And you were saying earlier that any concerns about this could be addressed by the policy committee. My question to you is, why would this committee not just focus on just the dollars and, hope that the policy committee will include this language that we're proposing in this amendment and fix, the possible concerns? So basically, this is still contains policy, this bill, and this is the finance committee. So I'm just trying to get your, take on this.
Thank you for the question. That certainly is one reasonable approach. But I'd point out to you that Amendment 804 and some of the other amendments don't deal exclusively with the building and its funding. There's trauma-informed care in these. Is that a policy decision which we should wait and send back to Children and Family Law in 120? I think the answer is no. I think it's important that we go ahead with a comprehensive solution and nobody is ever going to get it right the first, second, or third time, and we will polish it next session with 120. And the following session of the legislature, it will be further refined, because we can always make things better. And I think it's important that we take a significant step now rather than try to do this thing piecemeal, because piecemeal sometimes creates more problems than a comprehensive solution which can be amended in the future.
Thank you.
Further questions from committee? Representative Petrie.
Thank you, Mr. Chairman. Thank you for taking my question. Nice to see you.
Same here, sir.
Is there a danger of these juveniles sidestepping the juvenile justice system? You see on our southern border, they use juveniles because they know that their punishment or whatever care, whatever you want to call it, is a problem.
Thank you for that question, Representative Petrie. Like you, I've probably watched enough television programs over the decades to know that in police dramas, it's a common constant to use juveniles as various abettors, lookouts, mules, because everyone knows that no matter what the state, juveniles receive different treatment. I don't think that that issue is determinative of this bill. I think that issue will be here no matter what happens. To the extent that these juveniles are, in fact, extremely violent, then this bill deals with those, and they will be properly detained, committed into the replacement facility.
Further from the committee? Seeing none, thank you.
Thank you, Mr. Chairman, and thank you, members of the committee.
There had been a plan, if the time permitted, to do work session on this. Obviously, there isn't. It's noon. We're coming back here at 1 to exec several bills for full committee. So let's have a lunch hour and be Representative Hall, last word.
If I may, real quickly, only because simple assault came up. I want everybody on the committee to understand there's a 2006 New Hampshire Supreme Court case that was prosecuted by AOT, and I don't remember the name of it, but it had to do with the definition of simple assault, and it was where one attorney on leaving the courtroom pushed another attorney with their thumb against the shoulder, and that case went all the way to the Supreme Court. And simple assault is taking your thumb and pushing someone else's shoulder. I want us to understand the legal definition when we start talking about some of these things, because there is a criminal element in all of this, and that is not the same as some of the serious crimes that we hear. Thank you.
Okay, I will announce that the blue sheet has two names. Both of them have testified before us, one pro and one con. And there also will be some written testimony that you can read that has been submitted online. We'll ask Mr. Ripple to see how many of those there are and whether or not it's going to be copied. So have a good lunch. We'll see you all at 1 o'clock. Thank you very much for your patience. Thank you for your attendance.
Gotta get rid of this.
Yep.
It'll go away, right?
I'm tired of it.
Still gonna come join you for lunch, or?
What's that?
Yeah.
Mic check 1, 2.
All right, committee members. Each of you has received a packet of bills. You may not have all the same bills as the person next to you because you should have the bills already in your possession for your division. The bills you have in this packet are for the divisions that you're not in because you need to be familiar with those when we exec them. We have a deadline on 49, House Bill 49, tomorrow. So since we had a work session and it went right up to lunchtime, and I decided to stop then and have lunch, now I'd like to proceed forward and try to get something passed on 49 since it has a deadline. So we had discussions this morning on our amendment 767, and there were some weaknesses. And I'm going to discuss those with two other chairmen, the chairman of Judiciary who's here, Representative Lynn, and the chairman of Children and Family Law, Representative Pearson. So first, I'll allow Representative Lynn to briefly introduce the amendment, and if we've heard a lot about what it's going to do, you don't have to go into too much detail, I hope. Representative Lynn.
Thank you, Mr. Chairman and members of the committee. What I guess I try to make is really very brief because I would just be repeating what I said earlier. The amendment that I have proposed, and which I guess would need to be introduced by a member of this committee, which I'm not on, but it's 892, and what I would say is 892 is exactly the same, literally word for word, as 767, except that it adds a new section 8 to the bill and then renumbers what comes after section 8 in 767, renumbers it so that when you get to the end, there's one more section. And in the section 8, which is what's new, it just makes a 2-word change. It deals with RSA 169B14, which is the section of the Juvenile Justice Act that deals with detention, and it basically adds the words quote or 169B colon 19(1) parenthesis M close parenthesis. And the purpose of that is simply to make it clear, since you're creating the section M in 19 as another basis for commitment, I think you need to make the change to 14 so that it's consistent, so that, you know, I completely agree with the idea that somebody shouldn't be able to be detained for an offense that they couldn't be committed for. But since you're now saying, well, you can be committed for M, it seems to me you have to change 14 to be consistent. So I guess what I would say is that's really the sum and substance of the amendment, and I'm happy to answer any questions.
Questions from committee members? Where is their chief questioner? Oh, there he is. All right.
All right. Thank you.
And Chairman Pearson, there was some thought earlier that, and the reason we had a specific hearing for the previous amendment was because it was getting into policy areas and it was a little non-germane to what the original House Bill 49 was. Now, we know you have House Bill 120, and I believe you have retained it with the thought that if there was something that needed more work on what we might pass here today, because we're on a deadline, that you could put it in 120, which you've retained, and then bring it back in January. Does that sound reasonable?
I agree.
Amanda,
So
few
if
words,
you
thank
want to send us Amendment 767 our way too, we'll be working on this. individuals have already been so excited about it that they're starting to ask questions all over the place. And I don't think they're going to do it what's on our summer vacation list, but yeah, we would be very happy to take up 120 with this 767 amendment or anything else you care to send us that's policy.
Thank you. That helps us try to get 49 out of here today so it can make the deadline. Thank you, Chairman. All right. Division 3 Chair, how do you wish to proceed?
I think we have 0767 and the Lynn amendment. I think they are slightly competing. I would like to move actually that we accept the Lynn amendment, and that motion would need to be seconded.
Is there a second? Representative Emmerich seconds the motion to pass Amendment 0892H for House Bill 49. Further questions from any committee members? I appreciate that there are not. So everybody seems to understand what Representative Lynn made the changes to this amendment that he spoke of this morning. I believe Director Ribson has seen them. As you heard, we also have another shot at 120. So anything that we overlook now hopefully can go forward in 120 and be up next year. If you can come forward.
Hi, Joe Ripsum, Director, DCYF. And I do appreciate what Representative Lynn was trying to do with this amendment in terms of reconciling the detention and the commitment changes. My biggest concern in the immediate term is that if 8 and 9 become law and become applicable before 120 fixes them, right? Because for some reason it seems like we're deciding to move the policy through here and then fix it later instead of actually fixing the policy before we move it through. If those become law immediately, they will undermine SB 94, which is wildly successful in a national model today. And that would be devastating.
How will they underline it?
Because you will change the incentives of law enforcement to be willing to accept our recommendations to not send kids to court. What will happen instead is law enforcement will be afraid that if they don't stack up 3 prior charges for things like domestic violence and simple assault, that those kids will then not be able to be eligible to be detained in case it becomes necessary in the future, and will be more likely to say, we're going to charge these kids each time instead of letting them be deferred, which is what's happening today with wild success under SB 94. The other thing that will happen, that happens today with, I think, great success, is kids who are currently on probation, they typically don't get new charges. They just get violated on probation and the court brings them back, reads them the riot act, whatever, but they don't get new charges. With this change, you're going to incentivize that those kids stack up new charges. So you've really changed the process by which folks are going to have to make their decision about whether or not to bring charges. And the entire system we've built in the past couple of years is not just around keeping kids out of SYSC, it's about keeping them out of the system as a whole, not bringing charges at all. And what this is going to do is incentivize the exact opposite behavior from law enforcement and prosecutors when they're worried about maintaining community safety.
Okay, and we're going to let Judge Lynn respond. My experience was when we asked the county attorney to give us a list of the cases they had, virtually everybody that was arrested had 5 charges against them. It was always resisting arrest, attempting to leave, and all this kind of thing. Nobody ever got arrested for one thing. And if they had any drugs, it was intent to distribute, possession, all those things, everything got added onto it. So I don't know as that would be any different when they arrest, because it seems to be a pattern. Anyway.
So this requires that there be 3 separate incidents, not multiple charges on a single incident, right? So that's actually not not the circumstance that we're talking about. You could have 3 separate incidents with 10 charges each, but they'd have to be 3 separate incidents in here. It's not just one incident with multiple charges. And it's 3 separate incidents that have been proven or adjudicated within a 12-month period. So again, I don't think it meaningfully changes the census of who's at SYSC, because when we look at that, the kids who actually get detained and committed have dozens, unfortunately, of prior incidents. But what it will do is meaningfully impact the decisions that prosecutors and law enforcement make on the ground about whether to bring a charge in the first place. And that's what I'm really worried about more than anything.
Thank you. Representative Lynn.
Yeah, Mr. Chair and members of the committee, I guess I just wanted to say something because I don't want the committee to misinterpret my position. When I offered Amendment 892 with the change that I explained a moment ago, I did that after discussions with Representative Erf because basically what I said to him and what I say to this committee is, if you're gonna include the changes that are now in sections 8 and 9 of Amendment 767, if you're gonna do that, then I hope you will consider my amendment instead, which makes the change to section 14. But that's really sort of my fallback position, if you will. I agree completely with Mr. Ribson, but I think that the best, if the committee wants to know what the best thing to do here, at least from my perspective, it would be just don't take that 254 language, the 8-9, section 8 and 9 out of this completely. Don't deal with that at all. Let that go to child and family. I think that would be the ideal resolution. That's what I would suggest.
But that's in your amendment, though.
No, it isn't.
That's not 254 language.
No, my language includes the 254 language that was in Representative Erf's and Representative Hole's amendment, and it added that one other section I talked about before. I guess, as I said, my view is if you're going to, pass the 254 as part of this bill, then please include, please do it via my amendment rather than the 767 amendment. But I would think the better thing to do is not include the 267, the 254 language at all.
So Mr. Chair,
Representative,
if I may,
Yes.
I would like to change my motion, and my motion would be, and hopefully the person who seconded will support this. I would like to have both 0892, 0767 both retained so that children and family law can consider it as part of HB 120.
does this affect the funding going forward?
There are 2 other amendments before us, my amendments, that both address the funding and the operations. They're both good bills that get us extremely close to SB 1.
Are they simply providing the wherewithal to move forward on the construction and fund it and pick the spot?
Yes, sir. One of the 2 amendments is very short and very narrowly tailored to that. The other one incorporates all of the operational aspects that the community has been lobbying for 2 years on having a trauma-informed therapeutic-based model.
Do we have that amendment before us?
We have both, and they were both basically introduced last time we heard 49 a week ago.
Is that 0804?
One is 0804, and the other, if the committee wants to just do something short and simple, is 0738. Between the 2, I prefer 0804 because it gets us closer to being at SB1. But if all we want to do is to get this onto the floor and have the money taken care of, then 0738 accomplishes that.
Okay.
We need a second on that.
So your motion was to retain both 767 and 0892? Is that correct?
Yeah. And I don't care if we do them one at a time or together, but yes, retain 0767 and 0892.
All right, since we started with 0767. If what?
You can retain an amendment.
It would be easier if you withdrew that motion.
What would be a superior motion? I really don't want the committee to pass these out of the committee today because there are better alternatives and the Children and Family Law has not yet heard these policy issues.
Then I would suggest you withdraw the amendments. Representative McGuire.
I would suggest you just move the amendment that you prefer.
The one I prefer is 0804 that we haven't heard from about in a week. Both the other two were current today, but I did introduce 0804 a week ago. And for anyone who's been following this, and when they read this, this is essentially the completion of the Senate's SB1 that passed 24-0, and 0804, I think I can say that all of the activists here have looked at it and have supported it. And I think the department has supported 0804. The governor's office has called me and said it. The Senate voted 24-0. So the preponderance is that we really ought to just pass 0804.
In an earlier time where we looked at 0804, and Representative Hull brought up the fact that he thought there might be a challenge on using ARPA funds. So I forwarded that question, that's about a week and a half ago, to the Attorney General and said, what do you think of this? Is it true that Maine has been sued for trying to use ARPA funds to fix a jail? He wrote back and said he found no evidence of that. He said there had been a story and someone had written a letter to the paper saying we shouldn't do this. But he said there was no formal thing filed, and he and the attorney for the ARPA funds had both reviewed the proposal. So that's, again, another reason why we have to move forward while these ARPA funds have to be committed within the year. And then the building has to be built by 2026, I believe. Is that what you recall?
Yes, that's correct.
So there is a reason to move forward on something that they can begin to go and request these ARPA funds. So a short and sweet one would be a good way to go. So now the motion we have before us is to accept 0804 amendment, which will be followed by an ought to pass as amended.
Mr. Chairman?
Representative Hewitt.
Well, Amendment 0804 was introduced in the Division 3?
It was.
Well,
I thought it was.
Also in full finance.
It was in full finance. Was it introduced in full finance?
It was introduced in full finance. Okay.
Yes.
Well,
Yeah, but
I
we want to get the procedures right, don't we?
that's right, because I don't want to vote on something I've never seen or has never
Yes.
been introduced.
Yes, that's, and I have notes on it. That's where Representative Hull brought up the fact about, is there going to be a challenge to using ARPA funds? So I run that by the Attorney General at the request of the committee. He's come back and said not to worry, that the ARPA attorney and himself think it easily satisfies the ARPA requirements. So that's an important way to get this funding going so we can start to build this. Representative
Popovich Miller, got it.
Popovici Muller.
Thank you, Mr. Chairman. I don't know whether the question is appropriate at this time or not, but I'm just trying to understand whether, for example, we would maybe be better off if we just looked at the 892 amendment and just changed the effective date to something like July 1st, 2024, to address Director Ipsam's concerns that the changes may be effective immediately, while at the same time giving a bit of time, giving a clear idea of what we want and letting the appropriate policy committee work on this.
The director already had concerns with what it would do to incarcerating people that were brought before
If it becomes applicable immediately,
What?
If it would be, in effect 60 days after the passage. I was asking about a July 1st, 2024 effective date.
That would require further amendments, which I'm trying to get the process moving. Representative Edwards.
I don't want to put words in Mr. Ribson's mouth, but I believe he's on record as already supporting my amendment from last week, 0804, and that he's shown up here today to oppose 0767, and that when you add Representative Lynn's concern, I think by extension he would probably oppose 0892. So of these three, there's one that you are currently in favor, 0804. Is that true?
That's correct. Yes.
So we have a motion.
What's the motion?
Motion is to adopt Amendment 0804. Does everyone understand that and have it before them? All right, the clerk will call the roll on.
Wait, just a question.
Further questions? Representative Wallner.
Yes, I just want to say that I'm going to vote no on this because for me, the most important piece in 0767 was the area where we limited what children would be placed in the Sununu Center or the new Sununu Center. And I'm not going to talk for very long. I'm going to be really short, but I would like to bring everyone's attention to the first 5 lines of the bill, of all of the bills. Every bill that we've seen so far has these lines, and the line says, placement in corrections settings can be harmful to children and lead to increased delinquency and adult criminal behavior. It should therefore be reserved for those circumstances in which the safety of the child and of the community requires such confinement. That to me sums it up. We need to be sure that this is limited to just the children who need this level of care. And that is the reason I will be voting no on this amendment.
It has that language that you just quoted.
But it does not have the sections in the bill, does not have the sections around limiting who can be placed at the Sununu Center, which is on page 6 of 0767 from line 17 down through line 32.
The motion before us is for 0804.
Right, and that's the one I'm going to vote against. Thank you.
Representative Grassi.
Yeah, I mean, and I thought the discussion we just had said that decision would be going to Children and Family Law, and that they would look at that and bring something in January, basically, to address that issue, and that was probably the more appropriate place.
That is correct.
Okay.
Representative Irf.
So I'm a little confused. I don't want to discuss 767 yet since it's not apparently up for discussion at this point, although I thought that's where we're going to start today. But I'm going to vote against this as well. The points that were made this morning are essentially the ones that have been made all along in this process, which have been the holdup here. It's not enough just to build a new building. That's the whole idea behind 767. It brings together the new building along with an approach that will, over time, reduce the census at Sununu, and more importantly, give kids the opportunity not to be in Sununu, but that might otherwise be there. I understand there's disagreements between the director and other people, both in the community and out of the community, and I would like the chance to discuss the details of sections 8 and 9, but we can do that later. I just want to say at this point, I'm voting against 084. And I'll also point out that 084 doesn't allocate any funding, so I'm not exactly sure how that's going to help get the Sununu Center built.
Further discussion, Representative Hall?
Thank you, Chairman. I'm going to take a brief minute and go back in history because this is clearly an issue that is difficult to resolve. To approve July 13th, 1855, at a meeting of the Governor and Council, July 20th, 1855, Honorable Frederick Smith of Manchester, Honorable Matthew Harvey of Concord, and Jose Eaton, Esquire of New Ipswich, were appointed as commissioners agreeably for the provisions and the purposes named in the foregoing resolution. I will skip to the resolution. This is about the design and installation of a reformation of juvenile and female offenders who have committed the offenses against the state. This is part of what was the deed to donate the property to the state. Why I bring this up is it is to take the, and I quote, it is to take those who would otherwise fill our jails and state prison and place them in an institution where they will both be morally and physically trained away from the vicious influence of hardened convict, where they will receive the advantages of a common school education, where all reasonable efforts will be made to prepare them to earn an honest livelihood, honorable by industry, and in some trade or other respectable employment. I think the point is we've been wrestling with this for 170 years almost at this point. This is a difficult task, but I believe there is a group here who wants to see a change in our statutes so that we are not sending someone there inadvertently. And I know that everybody in this room cares about the kids. We all have a common goal here. But when I read this document that was handed this morning to us about the way you could end up in the Sununu Center, I could imagine easily, okay, where a trafficked teenage girl ends up with 3 or 4 of offenses on this. And when we do the tally at the end of the day, with an overzealous prosecutor and the wrong judge, she might end up at the Sununu Center. And that is not the place to send a young female person. That would be the worst thing you could do to them. I believe we all want to do the right thing. I believe we all want to make sure that the right kids are taken care of, and some of them need compassion and love, as we heard this morning from former Representative Belanger when he heard, "I love you." That is a key element. I pardon for those who, I'm going to share a piece of scripture, and it's out of the Gospel of John, and it has to do with the adulterous woman. And I say this because he shows the mercy and care that's necessary for someone who has been caught by the law. Back then, adultery was a capital punishment offense. And he said, "Let he who is without the first sin cast the first stone." Why do I say that? Because it was that love and mercy that changed her life. We need to do the same. I cannot support this amendment. The changes that are in 767 and subsequently in 892, I think, okay, are the next step to make this work well. Thank you.
Are we ready for a vote on 804? That's the question before us.
I just want to support the motion. I'm going to vote yay on this. I want to point out that despite the hypothetical example of the sex trafficked girl, we have no testimony to suggest that's ever really happened. And I don't think any of us would want it to, but I think fortunately reality is that it probably hasn't. We heard from the Honorable Cody Belanger, who basically was opposed to 767, and from talking to him, I believe he would support 0804. This bill has been worked for 2 years. We have all of the advocates supporting 0804. We have the department supporting 0804. The Senate passed what the elements of 0804 and SB1 24-0. The governor's office is in favor of 0804. So despite kind of this last minute, let's change it and delay it in finance, we've heard from the chairman of Children and Family Law who said, give me you're tired, you're weak, you're huddled masses around the criminal code and send them over to children and family law so that they can hear it with their experience and with their jurisdiction. So I would ask you to, let's just stay the course. Let's complete the task. Let's vote in favor of 0804. Thank you.
Further discussion from committee? Seeing none, the clerk will call the roll. The motion is to adopt 0804 amendment. Clerk will call the roll.
Representative Erf,
No.
Yes.
son of a gun. Fancy stuff. No, I hit my, I was too zealous here. Representative Emmerich.
Yes.
Representative Griffin.
Yes.
Representative Mooney.
Yes.
Representative Edwards.
Yes.
Representative Bean. Representative Hole. Representative Sweeney.
Yes.
Representative Cambrose.
Yes.
Representative Popovici Muller.
No.
Representative Wallner. Representative Norgren.
No.
Representative Leishman.
Yes.
Representative Bucco.
No.
Representative Hatch is Hatch here? No. Representative Hewitt.
No.
Representative Heath.
No.
Representative Murray.
No.
Representative Ebel.
No.
Representative Chelerski.
No.
Representative Haken Phillips.
No.
Representative Stringham.
No.
Representative Weiler.
Yes.
Mr. Chairman, the vote is
You forgot-
11 yeas, 13.
You forgot.
Oh, I'm sorry.
Representative,
Are you in for
he's in for
Hatch.
Hatch? Okay.
Representative Grassi.
I'm sorry. Yeah, I know Mr. Grassi very well.
I'll vote yes.
You're voting yes, okay, so that screws that up.
12-4-13 against.
Wait a minute, wait, what, Grassi, let me get the paw straight.
Mr. Chair,
Representative Hall?
I move 767 and would like to speak to my motion.
Wait a minute, we haven't got a count.
I don't think we completed a vote.
Yeah, that's, I gotta be retrained. 13, yeah, no, it's 12 to 13.
12
12
for,
to 13.
13 against.
There
The
you go.
motion fails. Representative Hall is recognized for a motion.
Sure. I move 767, and I respect Representative Lynn and that one comment, and I am not a legal expert, so it may be an important change. And I look to him regarding that one additional line, but I know it hasn't been discussed in the committee, like the whole 767 amendment. If we move this, I do know that the good news is, even if it passes the House as is, there's the Senate, this doesn't become law tomorrow. There's lots of times to make a small one-line tweak along the way. If we move 767, it gets from this House Finance onto the floor, headed to the Senate, which is the right thing to do to make these changes.
Is there a second? Representative Erf seconds it. The motion before us is for 0767, which we all heard this morning. Is there any further discussion from the members of the committee? Representative Leishman.
Thanks, Mr. Chairman. Again, I'm not entirely familiar with all the Division 3 material that we see, but I guess I'm concerned when I've heard that the advocates have been supportive of the amendment that we just voted on and defeated, and that the department is in favor of the motion that we just defeated. So I'm really concerned where this is going, and maybe somebody could speak to me why the advocates were in favor of the last bill, or maybe they're not in favor of this one, but I'm a little concerned when the advocates have been so loud and clear of their support of the bill we just defeated, and along with the department. So I'm a little concerned about that, Mr. Chairman.
Representative Hall.
Sure. I'm willing to take my best to summarize. Several of the advocates came in on page 2, lines 24 and 25 in particular, right? And this has to do with the concerns that were raised regarding the staffing at the center. Several of them mentioned the PREA standards, which is the Prison Rape Elimination Act standards. I think all of those who looked into this, who were part of crafting this amendment, weren't looking for ratios at 1 to 8. We heard discussions, where's my notes? We heard discussions by some of the outside that they have ratios of 2 to 12 in other places. One even said 1 to 3. I think the reality is that the children that are in this center are going to require a certain level of attention. That attention is greater than 1 to 1. When we were discussing this amendment, we were trying to be at 1 to 4. I did some research, and in HB 1 of 2016-2017, which was when Director Ripsom would have been operating in the budget that he would have come into, there was 90 staff members allocated to Sununu Center for 70 kids. We have 87 in the current budget request. I think the goal of this was to try and make sure the facility was designed to be at the 4 or 5 members per child there, not at 8.
Mr. Ribson shook his head. I'll ask him what his comment would be about the staffing.
I started here October 2017. I wasn't part of that budget process. But when I came here, there was well over 100 staff at SYSC. So I'm not quite sure what that budget process was or what the language was that's being talked about there, but there were well over 100 staff at that point. At this point, I think it's somewhere in the mid 80s. That includes an awful lot of staff that we say we would no longer need if we were to be able to co-locate and be able to share services like maintenance, laundry, nutrition, et cetera, et cetera, et cetera.
Thank you. Representative Erf, do you want to comment? Any of the other people that did not? Representative Sweeney.
Thank you, Mr. Chairman. I'll be brief. I'm pretty disappointed with what we're doing right now and what it feels like this committee is doing. I think we're all operating under the correct assumption that we do have to build and construct a new Sununu Youth Services Center or youth detention facility, juvenile detention, whatever we want to call it, we have to do it. And we recognize that. To use the bill to construct the new center as leverage for policy changes that should be made in the policy committee is where we should be focused on. We should be tasked with the financing of the new facility. That is our job as the finance committee. Allow the policy committees that are new since the last time this language was discussed to work out among themselves the criminal codes and the ways that people get to the Sununu Center, the Youth Detention Center, and let us be tasked with building the thing. That's our job. And we're not Washington, D.C. We shouldn't be leveraging must-pass legislation in order to pass in other policy priorities that haven't gone through the current year policy committee. So I'm going to vote no on this amendment. There's another amendment that is more watered down, that if we can pass it, we can actually make sure the construction gets handled. And let's let other members of the legislature in the policy area for criminal activity and for children and family law to focus on the statutes that are sending people to the center, and let us focus on what we need to do to build the new facility. So I'm voting no on this. I'd love to vote yes on another amendment and get this bill out of here today, but we should not use, honestly, bad optics and bad politics to lever different policy positions onto this bill that haven't been fully vetted by the appropriate policy committee. Thank you.
Representative Erf.
Thank you, Mr. Chair. So I had hoped not to go down this road. I thought we'd be discussing the bills. But it seems that what's really important to folks here is that this is supposedly, we're rushing this through at the last minute. We need a little history of what's gone on this term. First of all, if you look at this bill, the actual underlying bill we're talking about today, it's a bill to extend the closing date of the Sununu Center and allocate the funds to pay for the Sununu Center through the rest of this fiscal year. That's a bill that should have been rushed through, because what was the deadline we had to meet? We had to stop the Sununu Center being closed in March. Did we rush this bill through? No, we didn't. What happened? And what happened behind the scenes? Unbeknownst to most of us here, certainly most of us, or I should say maybe just some of us in Division 3, the Senate put together a bill not only to extend the dates and fund for the FY23 period of time, but also to do a whole massive amount of other things. And they rushed that bill through over in the Senate. And in fact, that 24-0 vote was actually not a 24-0 vote, because that was an illegitimate vote that was held in the original dual committee meetings like we held here. When that came over here to the House, it was rushed through Children and Family Law. I didn't even learn about it until the day, literally the day of the hearing in Children and Family Law. And there were folks in Children and Family Law that I spoke with that were kind of surprised that it went through as quickly as it did. So the process has been rushed. That's absolutely true. Then it came here to Finance, and we were actually able to take out most of it and leave in there the critical pieces, the date change, the funding, and finding a site for the facility, and starting the design process. All of that is already in process, and all of that is going to take time. Nothing we're doing here today is going to impact the construction of the Sununu Center that couldn't be handled in another month or 2 months as far as the whole process is concerned. So I'm frustrated as well, absolutely, for sure. But this language has been vetted through this House last year. Were there issues with it, as Judge Lind has pointed out? Absolutely. And as Judge Lind has pointed out, he was very gracious in working with me to help improve it to the point where it's at now. We do have a minor disagreement. I'd call it a minor disagreement. He'd call it major regarding one piece that he asked about. But we have been working through this in the most effective way we can, given the constraints. This is an early bill. This has to be out tomorrow. Whereas it doesn't need to be, this issue does not need to be resolved tomorrow. We have the budget, the normal process that Finance runs, and you'll see that through all the rest of the bills we're going to exec today, is bills that are going to be, that have money, they get held, retained, and they get put into the budget. This process, this particular process, has been completely out of the ordinary as far as the way Finance works and the way bills normally proceed through the entire process. So I am voting in favor of this because I do think it is I'm voting in favor of 767 because I do think you need to put together both. It's not just about building a new facility. This new facility will not be built. We allocated funding, appropriated funding for the forensic prison, forensic, whatever the hell they call it, psychiatric, whatever it is, 4 years ago, and it still hasn't broken ground. So let's be realistic in terms of time frames. What we're talking about today is trying to rush, what we were talking about in the last vote we took was trying to rush things through. What we're suggesting is a better alternative, which will do all the things that one does. And in fact, it's based on the original amendment. The 767 is based on the original amendment that was voted out of our Division 3/Division 1 meeting several weeks ago, which you'll note you didn't see here today for whatever reason. So I am voting in favor of this, and I think it is the right thing to do for the children.
Representative McGuire.
Thank you, Mr. Chairman. Yeah, I'm not going to vote for this amendment but the amendment I would vote for is 892. That's different by 2, 3, 4 words, and it fixes a serious problem in the amendment that we have in front of us. The amendment we have in front of us has a different set of crimes to commit someone or to detain them. That makes no sense. 0892H, it's the same set of crimes for which someone can be committed and detained, right? Otherwise, they're identical. So why should we pass something we know right now is flawed when right on the table in front of us is something that's less flawed, which I would vote for. Thank you, Mr. Chairman.
Representative Popovici Miller.
Thank you. I just wanted to state that because of the concerns expressed by Director Ipsum because of the impact of this immediately, I'm not gonna support this amendment, even though I do like it in principle, but I'm concerned about the immediate effective date. So, just for the record.
Any further discussion before we vote? Seeing none, the clerk.
I'm sorry, just a quick one. The section in here, sections 8 and 9, it's without doubt been in testimony that these were the very first times those two sections have been heard anywhere in the House, anywhere in the Senate since this calendar year began and this legislature began. So this is brand new stuff. This is the example of rushing things through that could very well, at the request of the chairman of Children and Family Law, go over to them for the policy issue. So I'm going to vote against 767, and I hope you will as well. I might be inclined to vote for 0892 as an alternative to this horrible alternative.
Further discussion? Seeing none, the clerk will call the roll on the motion to adopt Amendment 0767.
Thank you, Mr. Chairman. Representative Earth,
Yes.
Representative McGuire,
No.
Representative Petrie votes no. Representative Emmerich,
No.
Representative Griffin,
No.
Representative Mooney,
No.
Representative Edwards,
No.
Representative Bean, Representative Hole, Representative Sweeney,
No.
Representative Cambrels,
No.
Representative Popovici Muller,
No.
Representative Wallner, Representative Norgren,
Yes.
Representative Leishman,
No.
Representative Bucco,
Yes.
Representative Grassi,
Yes.
Representative Hoyt, Hewitt, I'm sorry. Representative Heath,
No.
Representative Murray,
Yes.
Representative Ebel,
Yes.
Representative Tversky,
Yes.
Representative Haken Phillips,
Yes.
Representative Stringham,
No.
Representative Weiler.
Yes.
Mr. Chairman, the vote is 11 to 14 against.
The proposal dies.
May I make a motion?
Representative McGuire is recognized for a motion.
All right, I'll move amendment 0892H.
Is there a second? Representative Gambrill seconds. Do we need further discussion on this amendment?
Mr. Chair, I would just say that I still have a skinny version of this whole thing represented in 0738, and I hope I can make a motion on that after this vote.
Any further discussion? Seeing none, the clerk will call the roll to adopt Amendment 0892H on HB 49.
Thank you, Mr. Chairman. Representative Earth,
Yes.
Representative McGuire,
Yes.
Representative Petrie votes yes. Representative Emmerich,
Yes.
Representative Griffin,
Yes.
Representative Mooney,
No.
Representative Edwards,
I said I would, so yes. I hate it, though.
Representative Bean, Representative Hole,
Yes.
Representative Sweeney,
No.
Representative Gambrels,
Yes.
Representative Popovici Muller,
Yes.
Representative Wallner,
Yes.
Representative Norgren,
Yes.
Representative Leishman,
Yes.
Representative Bucco,
Yes.
Representative Grassi, Representative Hoyt. Hewitt. All right, I want it my way. I mean, it's.
I have a story
I'm
I'll tell
sorry.
you that will eliminate that. The answer to your question is yes.
Thank you. Representative Heath,
Yes.
Representative Murray,
Yes.
Representative Ebel,
No.
Representative Telersky,
Yes.
Representative Haken Phillips,
Yes.
Representative Stringham,
No.
Representative Weiler.
Yes.
Mr. Chairman, the vote is 21-4 in the affirmative.
We have adopted Amendment 0892H. I'm ready to accept a motion for House Bill 49 ought to pass as amended by Amendment 0892H.
Representative Weiler?
Yes.
There's still an amendment that's never received a vote that has received discussion by this committee, 0738. This is a skinny bill. All it does is it gets us out of the policy issues entirely, does an appropriation, and designate who makes the decision on the final site selection and size. It also uses the ARPA money. So what should we do with 0738? It's not received a vote in the committee.
Has it had a discussion before the full committee?
I attempted that last week and I was stopped because there was a non-germane amendment that we were supposed to discuss today, and we've done that.
I don't have a copy of that amendment. You said 08?
0738.
Oh, I do have a copy of it. Okay.
It's just basically a front page with a tiny amount on the back.
What
All this does is it has finance do finance stuff. It appropriates the money, gets us out of the policy issue. We've heard the chairman of Children and Family Law say, please let them do policy. So this is us where we can just do the money and stay in our lane.
Do you understand this would cancel the one that just passed with a fairly good vote?
I still wanted to get a vote because I want to know who I can rely on.
I guess we can do that. Representative Hole. Further discussion from the committee. Is everyone familiar with it? Representative Murray.
Will you just restate to be clear that if we pass this amendment, the previous amendment, 892, would be voided?
Yes.
I understood that there is a possibility that OLS can merge when there are two accepted amendments, or in this, if there are two accepted bills from the House floor that contradict each other a little bit, I understood OLS can do some merger. Is there no merging of amendments?
Depends on what the motion is for once we have established amendments, what ought to pass as amended states. Representative Murray. Mooney.
Thank you, Mr. Chairman. I believe to answer Representative Edwards' question, in amendment number 0738, line 5, it does say the bill replaces all after the enacting clause. To me, that's a replacement amendment. So though some amendments could be compatible, this does not appear to be a compatible one. It appears to be a replacement. Thank you, Mr. Chair.
Thank you.
I'd
I
accept
apologize.
her-
I've known you longer than Murray.
I
I don't know why I called you Mooney.
I
Murray,
accept
Mooney.
Representative Mooney's explanation. Still would like a vote.
I need a second, first and a second.
All right. Did you make a motion to adopt Amendment 0738?
I make a motion to adopt 0738.
Representative Griffin seconds. Any further discussion from the committee? Seeing none, the clerk will call the roll to adopt 0738H, and as has been stated, this will replace the one we just adopted. Thank you.
Thank you, Mr. Chairman. All right, let me get the 0738H. Representative Earth.
No.
Representative McGuire.
No.
Representative Petrie votes no. Representative Emmerich. Yes. Representative Griffin.
Yes.
Representative Mooney.
Yes.
Representative Edwards.
Yes.
Representative Bean. Representative Hole.
No.
Representative Sweeney.
Yes.
Representative Cambrils.
No.
Representative Popovici Moeller.
No.
Representative Wallner. Representative Norgren.
No.
Representative Leishman.
No.
Representative Bucco.
No.
Representative Grassi. Representative Hewitt.
No.
That's a tough one. My brain just didn't want to wrap around that. Representative Heath.
No.
Representative Murray.
No.
Representative Ebel.
Yes.
Representative Tversky.
No.
Representative Haken Phillips.
No.
Representative Stringham.
Yes.
Representative Weiler.
Yes.
Mr. Chairman, the vote is 8-17 and the motion fails.
Motion fails. I'll entertain a motion to ought to pass for House Bill 49 as amended in Amendment 0892H.
So moved.
92. Motion, is there a second? Second by Representative Hole. Further discussion from the committee.
Okay, we need to. Who, that was Earth?
It was Earth and Hole.
OTP. All right. Okay, thank you, Mr. Chairman. Representative Earth.
Yes.
Representative McGuire.
Yes.
Representative Petrie votes yes. Representative Emmerich.
Yes.
Representative Griffin.
Yes.
Representative Mooney.
No.
Representative Edwards.
Yes.
Representative Bean. Representative Hole.
Yes.
Representative Sweeney.
No.
Representative Cambrils.
Yes.
Representative Popovici Muller.
Yes.
Representative Wallner. Representative Norgren.
Yes.
Representative Leishman.
Yes.
Representative Bucco.
Yes.
Representative Grassi.
Yes.
Representative Hewitt.
Yes.
Representative Heath.
Yes.
Representative Murray.
Yes.
Representative Ebel.
Yes.
Representative Tversky.
Yes.
Representative Haken Phillips.
Yes.
Was that a yes? I'm sorry. Thank you. Representative Stringham
Yes.
and Representative Weiler.
Yes.
Mr. Chairman, the vote is 23-2.
Okay, we have adopted House Bill 49 as amended by amendment number 0892H. Thank you all for your consideration.
Mr.
We
Chair,
need to have that report written soon. Representative Hole.
I believe we have 26 here, unless someone left during the voting. Oh, thank you.
25 is the total membership. Guess everybody's here.
Unless, ghost people.
Okay.
Check his eyes.
All right, now we move to the bills that we are execing today. You should all have this sheet before you, showing it by division. And we'll start, and we have some of the reports written. The others, I hope, will be written before you leave today, because this has to go into the clerk soon. So, I'll recognize Representative Leishman to lead us for the bills that Division 1 has dealt with.
Thank you very much, Mr. Chairman. I'd like to recognize Representative McGuire, who moved the passage of House Bill 50 as amended.
Yes, I'd like to move Amendment 0997H to House Bill 50.
Second.
I'm sorry, what was that? Oh,
Motion is right there, 0997.
Shall I speak to my?
0997.
All right.
Is there any objection to doing this with just a show of hands? All those willing to adopt the amendment 0997, raise your
Oh,
hand.
yeah, Mike.
Thank you. Is there any objection to doing this by a show of hands?
I'd like to have a roll call, Mr. Chairman.
All right, request a roll call for adopting amendment
Who
0997.
seconded it?
Should I explain the situation, or is it?
Did anybody second the roll call?
Or second the,
All right, we'll have a roll call.
who seconded the motion? The initial motion?
Griffin.
Griffin, thank you.
Representative McGuire wants to speak.
Well, I can explain what's going on with this amendment if anybody has any question about it. This original bill did something that was in the budget last time, which was to have the state pay out of general funds 7.5% of the town's expenses for teachers, fire, and police, of the retirement part of their expenses. And we tried, the bill itself deadlocked in our division 4-4, as is. So we proposed this amendment, which was unanimous, to instead take a similar amount of money, in this case $50 million, and put it into against the unfunded liability of the retirement system. And that has the effect of saving money to similar effects, saving money to towns and other employers. But it does it slowly over time rather than all at once just in this biennium. Now, you should all have a kind of a gray looking piece of paper. And
Yeah, but that's, I'm sorry.
this is the analysis of this amendment.
Such a controversial
And
bill.
so you can see that spending $50 million in this way will save the towns and other employers $105 million over the next 20 years. All right, due to the magic of compound interest. So this is the fix the problem slowly sort of amendment rather than dump some money all at once and still have a serious problem next time. So yeah, so $50 million cost now gains us 105 over the decades. Now, my particular plan for this amendment, and I would invite comment, is to treat it sort of Senate style, in that is, this is a big change from the way the original bill was written. It's the same subject, but so I think it's completely germane, but it's a change of tactics, sort of. And so I would like this committee to vote this ought to pass, send it to the House floor, hopefully get an ought to pass there, and then ask to table it, and then put it into our budget, right? So do it sort of Senate style, where we pass the policy, and then that will be the House policy, and then, but it will be in the budget. We will not pass the bill on to the Senate as a standalone bill.
Further discussion on the amendment? Clerk will call the roll on adopting amendment 0997 to House Bill 50.
Thank you, Mr. Chairman. Representative Erf.
Yes.
Representative McGuire.
Yes.
Representative Petrie votes yes. Representative Emmerich.
Yes.
Representative Mooney.
Yes.
Representative Griffin, did I call you? Yes. Thank you. Thank you. I just trying to fool you. Representative Edwards.
Yes.
Representative Bean. Representative Hole.
Yes.
Representative Sweeney.
Yes.
Representative Cambrels.
Yes.
Representative Popovici Muller.
Yes.
Representative Wallner. Representative Norgren.
No.
Representative Leishman.
Yes.
Thank you. Representative Bucco.
No.
Representative Grassi.
No.
Representative Hewitt.
Yes.
Representative Heath.
Yes.
Representative Murray.
Yes.
Representative Ebel.
Yes.
Representative Tversky.
No.
Representative Haken Phillips.
No.
Representative Stringham.
Yes.
Representative Weiler.
Yes.
Mr. Chair, the vote is 19-6 in favor.
The amendment is adopted, 0997. I'll recognize Representative McGuire for motion.
Thank you, Mr. Chairman. I move ought to pass with amendment.
Motion and a second. Motion by McGuire, seconded by Griffin. Ought to pass as amended by Amendment 0997. Is there further discussion? Representative Heath, you got your mic on? Okay. Seeing no other discussion, clerk will call the roll. Ought to pass as amended. House Bill 50 amended by 0997.
Thank you, Mr. Chairman. Representative Erf.
Yes.
Representative McGuire.
Yes.
Representative Petrie votes yes. Representative Griffin. Yes.
You don't like me anymore?
What'd I do? Boy.
Skip one.
All right. Representative Emmerich.
Yes.
Representative Mooney.
Yes.
Representative Edwards.
Yes.
Representative Bean. Representative Hole.
Yes.
Representative Sweeney.
Yes.
Representative Cambrels.
Yes.
Representative Popovici Muller.
Yes.
Representative Wallner. Representative Norgren.
Yes.
Representative Leishman.
Yes.
Representative Bucco.
Yes.
Representative Grassi.
Yes.
Representative Hewitt.
Yes.
Representative Heath.
Yes.
Representative Murray.
Yes.
Representative Ebel.
Yes.
Representative Tversky.
Yes.
Representative Haken Phillips.
Yes.
Representative Stringham.
Yes.
And Representative Weiler.
Yes.
Mr. Chairman, the vote is 25-0 in favor.
Okay, we have adopted House Bill 50 as amended by Amendment 0997. Back to Representative Leishman for the next one.
Thank you, Mr. Chairman. The next one we have is House Bill 311. Many of you would know this as Bucco Bucks. This is moved to retain by Representative Hatch, who can't unfortunately be with us today, but that appropriation amount is in the governor's budget. That's the reason for our retaining.
I'll second.
Motion by Leishman, second by McGuire to retain House Bill 311. Is there any further discussion? Seeing none, the clerk will call the roll on retain for House Bill 311, and no report is needed on a retained bill.
Representative Erf.
Yes.
Representative McGuire.
Yes.
Representative Petrie votes yes. Representative Emmerich.
Yes.
Representative Griffin. Yes. Representative Mooney.
Yes.
Representative Edwards.
Yes.
Representative Bean. Representative Hall.
Yes.
Representative Sweeney.
Yes.
Representative Cambrose.
Yes.
Representative Popovici Muller.
Yes.
Representative Wallner. Representative Norgren.
She's absent.
Okay. Representative.
Oh, wait a minute, here she is.
Oh. Representative. Oh, all right. I'll wait till. Right.
Till she gets to her mic. Representative Nordgren, there's a motion. Representative Nordgren, the motion is to retain House Bill 311.
Yes.
Representative Leishman.
Yes.
Representative Bucco.
Yes.
Representative Grassi.
Yes.
Representative Hewitt.
Yes.
Representative Heath.
Yes.
Representative Murray.
Yes.
Representative Ebel.
Yes.
Representative Tversky.
Yes.
Representative Haken Phillips.
Yes.
Representative Stringham.
Yes.
Representative Weiler.
Yes.
Mr. Chairman, the vote is 25-0 in favor.
Okay, we have adopted the retained motion on House Bill 311. Representative Leishman.
Thank you, Mr. Chairman. The next on our plate is House Bill 384, relative to the new legislative parking garage. I'd like to recognize Representative Ebel.
Thank you, Mr. Chairman. So you have before you Amendment 042H to HB 384. I'd like to move passage of that amendment. If I had a second.
I'll second that.
Thank you, Representative
And can you
Sweeney.
explain what the amendment
Yes,
does?
I will. So now I'll speak to my motion. Okay, there were several changes. We worked on this quite a bit within the division. There are several changes to the original bill. The first change is that the amount of $25 million is going to be appropriated to the Department of Administrative Services instead of to the legislative branch. The division was persuaded that from an oversight and experiential standpoint, DAS was the appropriate agency to appropriate the money to and to oversee the project, and there was consensus on that within the division. The second change that was made was that $22.5 million will be coming out of the general fund, but $2.5 million will be coming out of the legislative account so that the legislature uses some of the money that we appropriate to it to construct its garage. So that was the second point. I would just add here that in the governor's budget, he appropriated $15 million. So this is $10 million more than what the governor appropriated, minus the 2.5 that is coming out of the legislative account. So we thought that was a good change. The next thing we're doing, I don't know how many of you are familiar with what we call the Capital Budget Overview Committee. The way things had usually been, capital projects went through the capital budget and then they would go for oversight to the Capital Budget Overview Committee. The way things have been going now, sometimes we have capital projects going through the capital budget. Sometimes, as we're seeing today, we have projects going that are capital infrastructure projects going through the operating budget. We all agreed, and so did the Commissioner Arlinghouse, that regardless of how they were funded, they still deserved oversight. And so there was great consensus on our committee that we should convert that overview committee to the Capital Project Overview Committee. So that's what we did. The next thing that we did was we created a joint legislative parking garage oversight commission to specifically oversee this rather large project, which is going to involve the construction of the parking garage, raising the DOJ building and also raising the much beloved Store Street parking garage. And what you'll see here, you can see who the appointees are. A couple of important points here is that the President of the Senate and the Speaker of the House, in addition to having a senator and a representative, they can also designate someone who can be a public member who might bring more experience to the project. And that is it. There is a reporting requirement. You'll see on page 3, line 4, that DAS is going to provide quarterly reports to this Legislative Parking Garage Oversight Commission. So that's what the amendment does. We sought to really build in more oversight to the project, and I hope that the committee will support the amendment.
Can we adopt the amendment by a show of hands? Representative Hewitt.
Mr. Chairman, on my copy of the sheet here, I note that the amendment number is 0421H.
Yes, I apologize. I had the McGuire amendment, and it's so seamless in our division, I read the wrong number. So I want to clarify that the motion that I am moving is 0421H, and I thank the judge for the correction.
He doesn't miss a thing. Okay. Can I do this by a show of hands? All in favor of adopting the amendment, please raise your hand. Any opposed? Okay. 24-1. All right. Hold. All right. The motion that Representative Abel now makes is?
Mr. Chairman, I'd like to move ought to pass as amended on House Bill 384.
I'll second.
Second by Representative Sweeney or Cambrell. You're all on Division 1. Clerk will call the roll on ought to pass as amended by 421 on House Bill 384.
I'm sorry, this is. 384. Got it. OTPA, all right, so we all know. All right, Representative Erf,
Yes.
Representative McGuire,
No.
Representative Petrie votes yes. Representative Emmerich,
Yes.
Representative Griffin,
Yes.
Representative Mooney,
Yes.
Representative Edwards,
No.
Representative Bean, Representative Hull,
No.
Representative Sweeney,
Yes.
Representative Cambrels,
Yes.
Representative Popovici Muller,
Yes.
Representative Waller, Representative Norgren,
Yes.
Representative Leishman,
Yes.
Representative Bucco,
Yes.
Representative Grassi,
Yes.
Representative Hewitt,
Yes.
Representative Heath,
Yes.
Representative Murray,
Yes.
Representative Ebel,
Yes.
Representative Swiderski,
Yes.
Representative Haken Phillips,
Yes.
Representative Stringham,
Yes.
Representative Weiler.
Yes.
Mr. Chairman, the vote is 22-3 in favor.
We have adopted House Bill 384 as amended by 421. Representative Leishman.
Thank you, Mr. Chairman. So next on our agenda here is 506. It's relative to the construction of a rail trail box tunnel in Derry. This was quite a lively discussion, so I'd like to turn this over to Representative McGuire.
Thank you, Mr. Chairman. I'd like to move inexpedient to legislate on House Bill 506.
Is there a second? Representative Hull seconds. Further discussion?
Would you like me to explain?
Please.
All right. So this is a bill brought to us by Representative Pearson, who I see in the room, and he made a fairly strong case for this. This is there's a very high expensive construction on I-93. There's a brand new exit 4A. It's a construction is, I think at this time, over $125 million worth. And in their original design, they had a crossing for a rail trail that would go through a tunnel under the connector road. And as the design progressed, DOT changed the design to have both a surface crossing as well as a kind of a circuitous second crossing under a bridge that was nearby. And so we had a lot of testimony on this. It was very active. But at the end of the day, our division decided not to second guess DOT's actions, which seemed to us to be reasonable, and also not to add any kind of potential delays to such an important project.
Motion before us is inexpedient to legislate on
Mr.
House
Ch-
Bill 506. Representative Griffin.
I'd like to add one thing to Mr. McGuire's comments. Who's second? There is an existing contract between DOT and the town, and this would put us in the middle of that situation, which would be a bad thing, I believe.
See another hand over there, Representative Papavici Muller.
Mr. Chair, first I would like to thank Division 1 for the amount of work they put into this. It is deeply appreciated, and my community members who got involved really are grateful for all the time and effort that you put in. Second, I would like to note that I would normally vote no on this ITL, but this is the original version of the bill, which includes the criminal penalties and all that. And even though I would support the substance of the bill, I will be unable to support that particular language. So I'll be unable to, do that. But I wanted to clarify. Thank you.
Further discussion?
Yes, Mr. Chairman, the bill was actually amended. We took that language out. Why we don't have a corrected copy, I'm not sure, but just so the record is clear, we did take that punishing language out.
Thank you. It is the original language here.
Further discussion? You still have your light on, Representative Papavici Muller. Turn your mic up. There you go. Clerk will call the roll on the motion of ITL, House Bill 506.
Thank you, Mr. Chairman. Representative Earth.
Yes.
Representative McGuire.
Yes.
Representative Petrie votes yes. Representative Emmerich.
Yes.
Representative Griffin.
Yes.
Representative Mooney.
Yes.
Representative Edwards.
Yes.
Representative Bean. Representative Hole.
Yes.
Representative Sweeney.
Yes.
Representative Cambrels.
Yes.
Representative Papavici Muller.
No.
Representative Wallner. Representative Ogren.
Yes.
Representative Leishman.
Yes.
Representative Bucco.
Yes.
Representative Grassi.
Yes.
Representative Hewitt.
Yes.
Representative Heath.
Yes.
Representative Murray.
Yes.
Representative Evil.
Yes.
Representative Tolerski.
Yes.
Representative Haken Phillips.
Yes.
Representative Stringham.
No.
And Representative Weiler.
No.
Mr. Chairman, the vote is 22-3 in favor of the ITL.
Thank you. We have ITL House Bill 506. Representative Leishman.
Thank you, Mr. Chairman. Next, we have House Bill 555, appropriating state general fund surplus towards the retirement system. Representative McGuire.
Thank you, Mr. Chairman. I move ought to pass on House Bill 555.
Is there a second? Representative Hall seconds.
So, may I speak? Yes. So this one is a straight policy bill. It has no financial impact, but it's about our policy in finance. So what it says is that if at such time the amount in the rainy day fund is equal to 10% of the biennial amount of the general fund, which today would be something like $300+ million, then any further surpluses, 75% of them would go to pay off the unfunded liability of the retirement system. So it would only take effect if the general fund has a very adequate cushion, or the rainy day fund has a very adequate cushion, and then we would start paying off our debts in the form of the unfunded liability. We're not there yet, but should we get there, I think this is a very, very good idea.
Further discussion? Seeing none, the clerk will call the roll on ought to pass on House Bill 555.
Thank you, Mr. Chairman. Representative Earth.
Yes.
Representative McGuire.
Yes.
Representative Petrie votes yes. Representative Emmerich.
Yes.
Representative Griffin.
Yes.
Representative Mooney.
Yes.
Representative Edwards.
Yes.
Representative Bean.
Yes.
Representative Hall.
Yes.
Representative Sweeney.
Yes.
Representative Campbells.
Yes.
Representative Popovich Muller.
Yes.
Representative Wallner. Representative Norgren.
Yes.
Representative Leishman.
Yes.
Representative Bucco.
Yes.
Representative Grassi.
Yes.
Representative Hewitt.
Yes.
Representative Heath.
Yes.
Representative Murray.
Yes.
Representative Ebel.
Yes.
Representative Telersky.
Yes.
Representative Haken Phillips.
Yes.
Representative Stringham.
Yes.
And Representative Weiler.
Yes.
Mr. Chairman, the vote is 25-0 in favor.
Mr. Chairman, may I suggest that this go on consent, because I don't think there's no dollar amount involved.
Any objection to this bill going on consent? Seeing none, yes, we can put it on consent. Okay, thank you for Division 1. We'll move on to Division 2. Representative Emmerich.
Thank you, Mr. Chairman. Our first bill is House Bill 129, and we have Amendment 0933 for consideration. The amendment basically modifies the original bill that was submitted, and also some of the original language that was in the RSA. You have a copy of the amendment in this amendment packet, and basically what the amendment does, it takes the bathroom installation language out of the original RSA and just says what made available, leaving it up to the school district on how they're gonna handle this, or the school. It changes girls to menstruating student in order to resolve future complications. The money has been deleted. This is a free of charge. The 28A suggestion was negated because we actually give the schools over $1 billion a year, and we figure hygiene products could be covered by that. And I believe that's it for the amendment. Second.
It was second by Representative Petrie. Further discussion on the amendment? Any objection to adopting it by show of hands? Seeing none, all in favor of adopting the amendment, raise your hand. Opposed? 2, 3.
3.
Okay.
And they were Earth, Hole, and Bean.
Okay.
Mr. Chairman, I would move HB 129 as amended.
Is there a second?
I second that.
Okay. Motion and a second ought to pass as amended by 933 on House Bill 129. Is there any further discussion? Seeing none, Representative Mooney.
Thank you, Mr. Chair. Does the fiscal note change with the newly adopted amendment?
Representative Emmerich.
Well, since we took the money out of the bill, I would assume there wouldn't be fiscal note any longer. Yeah.
So I have a question about that. As I recall the fiscal note, it's been a while since I looked at it. The fiscal note was meant to reflect the cost of the current law to the schools, did it not? Or was it the fiscal note strictly what it would cost the state if we met our 28A obligations? Can you remind me?
The fiscal note was calculated based on the original bill's formula for financing current costs and retroactive payments.
Thank you.
Some previous cases have gone to the Supreme Court on 28A issues for schools. And the decisions I recall were, you're already getting $1 billion. Find the money in that. So that was the way that it was decided in the Supreme Court. It isn't like you're going to nickel dime us for every last $1,000 when you're already getting $1 billion. So any further discussion? Seeing none, the clerk will call the roll on House Bill 129 as amended by 0933H.
Thank you, Mr. Chairman.
Motion is ought to pass as amended.
Representative Erf.
Yes.
Representative McGuire.
Yes.
Representative Petrie votes yes. Representative Emmerich.
Yes.
Representative Griffin.
Yes.
Representative Mooney.
Yes.
Representative Edwards.
Yes.
Representative Bean. Representative Hole.
No.
Representative Sweeney.
Yes.
Representative Cambrels.
No.
Representative Popovici Muller.
Yes.
Representative Wallner. Representative Norgren.
Yes.
Representative Leishman.
Yes.
Representative Bucco.
Yes.
Representative Grassi.
Yes.
Representative Hewitt.
Yes.
Representative Heath.
Yes.
Representative Murray.
Yes.
Representative Ebel.
Yes.
Representative Tulersky.
Yes.
Representative Haken Phillips.
Yes.
Representative Stringham.
Yes.
And Representative Weiler.
Yes.
Mr. Chairman, the vote is 22. Yeah, it's 22 to 3. I can't read my own writing. Sorry, Mr. Chairman. 22 to 3.
Thank you.
Could I possibly suggest going consent since we took the money out?
Yes, we will. Any objection to it going on consent? It will go on consent. Representative Emmerich.
Bill is HB 332
207.
Oh, I skipped 207. That's ought to pass. My apologies. HB 207 is an OTP. I'm falling apart here. HB 207, relative to school districts receiving unanticipated funds. Very straightforward bill. It was ought to pass 8-0. What it does is it takes the threshold for a public hearing for unexpected funds from $5,000 to $20,000. Very straightforward. I second that.
Okay, motion and a second ought to pass on House Bill 207. Is there any further discussion? Seeing none, the clerk will call the roll on the motion of ought to pass on House Bill 297.
That's 207, right? I'm sorry.
What did I say? 207, thank
Right.
you.
Not
207.
a problem. Yeah, we're catching something up here. All right, thank you, Mr. Chairman. Representative Erf.
Yes.
Representative McGuire.
Yes.
Representative Petrie votes yes. Representative Emmerich.
Yes.
Representative Griffin.
Yes.
Representative Mooney.
Yes.
Representative Edwards.
Yes.
Representative Bean.
Yes.
Representative Hole.
Yes.
Representative Sweeney.
Yes.
Representative Cambrels.
Yes.
Representative Popovici Muller.
Yes.
Representative Wallner. Representative Norgren.
Yes.
Representative Leishman.
Yes.
Representative Bucco.
Yes.
Representative Grassi.
Yes.
Representative Hewitt.
Yes.
Representative Heath.
Yes.
Representative Murray.
Yes.
Representative Ebel.
Yes.
Representative Tulersky.
Yes.
Representative Haken Phillips.
Yes.
Representative Stringham,
Yes.
Representative Weiler.
Yes.
Mr. Chairman, the vote is 25-0 in the affirmative.
Thank you. Representative Emmerich.
Thank you, Mr. Chairman. Next is HB 332, which is relative to school building aid. We voted 8-0 to retain this bill for consideration of the budget.
Mr. Chairman,
Representative Hall.
is on the HB 207, could we put that on consent?
Without objection, I don't believe it spends any money. It just gives permission. Any objection to it going on consent? It will go on consent.
I second that motion, by the way. That's for 332, is that where we're at?
Yeah, 332.
Okay. So that was Emmerich. That's, what was the motion?
Okay, the clerk will call the roll on retain for House Bill 332 FNAL.
Thank you, Mr. Chairman. Representative Earth.
Yes.
Representative McGuire.
Yes.
Representative Petrie votes yes. Representative Emmerich.
Yes.
Representative Griffin.
Yes.
Representative Mooney.
Yes.
Representative Edwards.
Yes.
Representative Bean. Representative Hole.
Yes.
Representative Sweeney. Representative Campbells.
Yes.
Representative Popovich Muller.
Yes.
Representative Waller. Representative Nogren.
Yes.
Representative Leishman.
Yes.
Representative Bucco.
Yes.
Representative Grassi.
Yes.
Representative Hewitt.
Yes.
Representative Heath.
Yes.
Representative Murray.
Yes.
Representative Ebel.
Yes.
Representative Telersky.
Yes.
Representative Haken Phillips.
Yes.
Representative Stringham.
Yes.
Representative Weiler.
Yes.
Mr. Chairman, the vote is 25-0 in the affirmative.
Motion passes. Representative Emmerich.
Thank you, Mr. Chairman. Next is House Bill 468. This is making an appropriation for the Department of Education to recodify their existing laws. We're retaining this one while we're doing some homework because the original bill was for $100,000, and you've seen the size of the education laws. They're never going to get done for $100,000, but we have no idea what to budget, so we're working with OLS to give us some idea, so we might be able to work this into the budget. But for now, we'd like to retain this. The vote was 8-0. Second.
Further discussion on House Bill 468. Seeing none, the clerk will call the roll to retain House Bill 468.
Thank you, Mr. Chairman. Representative Earth.
Yes.
Representative McGuire.
Yes.
Representative Petrie votes yes. Representative Emmerich.
Yes.
Representative Griffin.
Yes.
Representative Mooney.
Yes.
Representative Edwards.
Yes.
Representative Feeny. Representative Hole.
Yes.
Representative Sweeney.
Yes.
Representative Campbells.
Yes.
Representative Popovici Muller.
Yes.
Representative Waller. Representative Norgren.
Yes.
Representative Leishman.
Yes.
Representative Bucco.
Yes.
Representative Grassi.
Yes.
Representative Hewitt.
Yes.
Representative Heath.
Yes.
Representative Murray.
Yes.
Representative Ebel.
Yes.
Representative Telersky.
Yes.
Representative Haken Phillips.
Yes.
Representative Stringham.
Yes.
Representative Weiler.
Yes.
Mr. Chairman, the vote is 25-0 in the affirmative.
Okay, that will be retained. Moving on, Representative 541, Representative Emmerich.
Thank you, Mr. Chairman. This is relative to school building aid and grants, making appropriation therefore. As in all of these bills, we are voted 8-0 to retain and discuss as part of the budget.
Second.
Further discussion on the motion to retain House Bill 541? Seeing none, the clerk will call the roll on retain for House Bill 541.
Thank you, Mr. Chairman. Representative Earth.
Yes.
Representative McGuire.
Yes.
Representative Petrie votes yes. Representative Emmerich.
Yes.
Representative Griffin.
Yes.
Representative Mooney.
Yes.
Representative Edwards.
Yes.
Representative Bean. Representative Hole.
Yes.
Representative Sweeney.
Yes.
Trick myself. Representative Campbell's.
Yes.
Representative Popovici Muller.
Yes.
Representative Wallner. Representative Norgren.
Yes.
Representative Leishman.
Yes.
Representative Bucco.
Yes.
Representative Grassi.
Yes.
Representative Hewitt.
Yes.
Representative Heath.
Yes.
Representative Murray.
Yes.
Representative Ebel.
Yes.
Representative Tulersky.
Yes.
Representative Haken Phillips.
Yes.
Representative Stringham.
Yes.
Representative Weiler.
Yes.
Mr. Chairman, the vote is 25-0 in the affirmative.
We have voted to retain House Bill 541. Representative Emmerich.
Thank you, Mr. Chairman. House Bill 546 is relative to the school building aid program. As in other of these educational funding bills, we are voted to retain 8-0.
Second.
Further discussion on the motion to retain House Bill 546? Seeing none, the clerk will call the roll on the motion to retain House Bill 546.
546. Boy, I screwed that one up. That's to retain. All right, Representative Earth.
Yes.
Representative McGuire.
Yes.
Representative Petrie votes yes. Representative Emmerich.
Yes.
Representative Griffin.
Yes.
Representative Mooney.
Yes.
Representative Edwards.
Yes.
Representative Bean. Representative Hole.
Yes.
Representative Sweeney.
Yes.
Representative Campbell's.
Yes.
Representative Popovici Muller.
Yes.
Representative Wallner. Representative Norgren.
Yes.
Representative Leishman.
Yes.
Representative Bucco.
Yes.
Representative Grassi.
Yes.
Representative Hewitt.
Yes.
Representative Heath.
Yes.
Representative Murray.
Yes.
Representative Ebel.
Yes.
Representative Tulersky.
Yes.
Representative Haken Phillips.
Yes.
Representative Stringham.
Yes.
Representative Weiler.
Yes.
Mr. Chairman, the vote is 25-0 in the affirmative. George.
We have voted to retain House Bill 546. Moving on to Division 3, Representative Edwards.
Mr. Chair, Division 3 considered House Bill 527 relative to Medicaid reimbursement rates for certain assisted living facilities. We voted 9-0 to retain it so that we could consider it as part of the budget effort. The basic issue that we observed was it was very narrowly defined and perhaps too narrowly when we think we need to take a broader look at it.
Further discussion?
Who seconded that? That's 527?
Yeah, Mooney was the second.
Mooney?
Further discussion
And that's your bill?
on the motion to retain House Bill 527. Clerk will call the roll.
Thank you, Mr. Chairman. Representative Earth.
Yes.
Representative McGuire.
Yes.
Representative Petrie votes yes. Representative Emmerich.
Yes.
Representative Griffin.
Yes.
Representative Mooney.
Yes.
Representative Edwards.
Yes.
Representative Bean.
Yes.
Representative Hole.
Yes.
Representative Sweeney.
Yes.
Representative Cambrils.
Yes.
Representative Popovici Muller.
Yes.
Representative Waller. Representative Norgren.
Yes.
Representative Leishman.
Yes.
Representative Bucco.
Yes.
Representative Grassi.
Yes.
Representative Hewitt.
Yes.
Representative Heath.
Yes.
Representative Murray.
Yes.
Representative Ebel.
Yes.
Was that a yes?
It was.
I'm sorry. Representative Tversky.
Yes.
Representative Haken Phillips.
Yes.
Representative Stringham.
Yes.
Representative Weiler.
Yes.
Mr. Chairman, the vote was 25-0 in favor.
Representative Edwards.
Mr. Chair, I would move to reconsider HB 49. That's a joke, by the way. A little levity.
Thank you. I don't want to hear any
Just a
more
little
than
levity. I
necessary.
saw Representative Heath grabbing something to throw. We've discussed HB 49, and I think we've come to a previous conclusion.
Just remember the Ides of March is upon us.
Remember the amendment. It is.
What do we? Do you need a blurb on retain? What are we doing now? Oh, you don't. Sorry.
No, this was ought to pass as amended.
It did come out, ought to pass as amended with the 0892 amendment, and somebody needs to write that blurb.
It's already written.
It's already written.
Okay, our earlier vote on the amendment was 21-4, and on the ought to pass as amended was 23-2. Will the committee accept that vote, or do you want to do it again? Anybody want to go through that again?
Mr. Chairman, I thought Representative Edwards said he was joking. And then we moved on and had a private side conversation. I missed something there.
He was joking.
Okay, then what is the chairman asking us to do?
So earlier, about an hour ago, we voted on several amendments. The one we adopted was 0892 by a vote of 21-4. And then we moved to ought to pass as amended by that amendment. Then the vote was 23-2. That was about 3 o'clock or so.
Yep.
So does anybody wish to do another roll call on this? I am so tired of this bill.
Chair. Just a question. Did that end up being on the consent calendar or not?
I will not put it on consent. And there's and another rule we usually follow, if there's money in a bill, it doesn't go on consent. Unless it's ITL. We see a lot of FN bills on consent with an ITL. That's fine. But if there's money to be spent, it's not good to have it on the consent calendar. Does anybody wish to have any further roll call on ought to pass as amended House Bill 49 by Amendment 0892? Good. Thank you very much. Now, tomorrow, the Representative Wallner.
I think you're getting ready to do just what I was going to ask you. Could you kind of outline for us what we have for the next couple of weeks, what our schedule's going to be, what our deadlines are particularly?
We have deadlines at the end of March. We'll probably go before, let's see, Mr. Ripple or Mr. Landrigan can tell us when we have to come before the House for a presentation. I think it might be on Thursday, the 30th, but I'm not certain.
Good afternoon.
Good
So-
afternoon.
So I'm going to work starting from today. So looking into next week, we have a couple house session days. The 22nd, 23rd, we do have session tomorrow as well. The 23rd was the day that we've been kind of holding as the division deadline. So we're hoping everything is decided at the division level by that day. That will give us that weekend to put together the detail changes, the packages, all the amendments for that following week, which is Monday, the 27th. Those days is when we'll exec House Bill 1 and 2, hear from the division chairs, do the presentations of the division's recommendations, as well as, 20, 30, however many more bills that the committee still has, we'll have to exec that week. Jumping forward after the final day to report, the budget would be the 30th. Jumping forward that following week, there would be a House briefing to, the Finance Committee would brief the House on the House passed budget, the House Finance passed budget. I don't know the exact date for that. Usually is either that Monday or Tuesday, so the 3rd or the 4th, and I don't think that's been scheduled yet.
The 3rd or 4th of April?
April, yes.
Okay, so we've got some time. In divisions, can you brief us on the plan that you have? We will probably meet again to exec some more bills that we still have before us, I believe. Hopefully, we can do that quickly. Representative Leishman, do you want to spell out your plans?
Sure, Mr. Chairman. We're just about done with meeting with everyone. We've, I would say, about 85 or 90% done with our work. We should have no trouble meeting the deadline and having everything ready for presentation by the 23rd.
Do you have anything immediately ahead that you want to discuss?
We do have a couple of bills that are holding us up on retirement. That's pretty much our only concern. House Bill 463 or
436.
And 571. Is that the right one? Other than that, we'll have about 20 bills coming to the full committee.
And also 250.
Yeah.
And I'd like to, may I?
Oh, sure.
Yeah. So this Friday at 1 o'clock is when we're going to have the presentation from the ED&A committee to our division on all of the licensing provisions in House Bill 2. Currently greater than 50% of the pages, but a lot of those will go away. So, but we'll get all the details from them Friday at 1 if anyone wants to join us.
1 o'clock, thank you. I'll try and make that. Division 2.
Well, as soon as we break from this session, we are going to reconvene in Division 2 room today for about an hour. LBA has some additional information for us, and then we reconvene again Friday morning at 10 for the day to keep slogging along.
Thank you. And Representative Edwards for Division 3.
I think we're getting pretty close. We have a lot of discussion. It hurt not having yesterday's workday, but I think we're going to end up making all the deadlines anyways. I don't think we're going to be in agreement, but we'll be done because we'll be out of time.
Representative Hole.
Thank you, Mr. Chair. The schedule that was given to us for the calendar, is there a way to get that as a document so those of us who are visual can look at it and know when we have obligations?
Yeah, I think it'll all go in the calendar. Representative McGuire.
Yes, there's also on the cork board here in Janet's office is a calendar which you can pull down and copy and put back. So
I appreciate all your patience for the long public hearing we had. It was shorter than many that some of us have sat through. I think I had one for 10 hours some years ago. This was a little under 4. I think that was pretty good, and I appreciated the fact you all listened and took any notes you wanted to, and we'll be bringing those up, some of the things as you look at those sections of the budget. It's not uncommon for us to have everybody that comes to us wanting to spend more money. That's usually the way I think one time somebody came and said, I think you should cut the budget. I think that was only once. But I appreciate the fact you were all there and you were all patient and you all listened and attentively. And I think that's what the public appreciates. I've got to congratulate Joe, who said time and nobody argued. That was also very uncommon. Because normally we'd say time and they'd say, I just got 2 more pages or something like that. And then I'd have to say, please wrap it up in about 3 sentences. And sometimes I was successful. And then we also had to brief the Sergeant at Arms staff, and they would start moving slowly up the aisle to take the person out. But we're never allowed to grab them or put hands on them. But some of them finally took the hint that, okay, you've said enough. And especially, I was glad that some people appreciated the fact I was able to, not everybody put who they were speaking for, but when they put what group they were speaking for, I could group them together and then say, okay, those are the 3. You're all talking about the same thing. You don't need to say the same thing. Just if you agree or if there's something to add. That was successful, saved us probably 10 or 15 minutes throughout the night. So we finished in less than 4 hours, which is somewhat of a record. So I appreciate all the patience you had. Sorry I didn't provide a meal. I was thinking if it was going to go real late, I'd have to order out, but it went pretty well. And I appreciate the attendance of this committee and the fact that you're all willing to work so hard on this, because the budget is a challenge. And it came to us, this is one of the more challenging times on this budget. 2 years ago, we found that the governor's budget was 70 million more than what Ways and Means told us. This time, Ways and Means was 2 weeks late and then told us they were 85 million over what they said we could spend. So that left us right away trying to do cuts. And then when we had all those bills, 52 of them all wanting to spend more money, it's another challenge. So I appreciate the fact you've all studied very hard and tried to figure out a way to make it all work, because that's what we have to do. That's why we're here on the Finance Committee. That's why some of us come back year after year to do this, because it is an intellectual challenge that keeps us all on our toes. And there are ways we discover that, yes, we can do this and it still looks good, and maybe the House will accept it. One of the things that shocked me, in the past, I looked at what was called a tax expenditure limitation, which I heard of in 2000 from people in Colorado. They passed the Taxpayers' Bill of Rights. In it, it said that a budget cannot increase over the past budget by more than the rate of inflation plus the population increase. So I've asked LBA, tell me what that is. Here's the surprise. In the 2 years prior to this budget, inflation was 12.7%. Population increase was 1.5%. Those add up to over 14%. I don't think any of us want to increase a budget 14% plus. We don't have the revenue. The governor's budget was well short of that, and our budget will be even a little shorter. So if you have talks with any of the other members who might be thinking, oh, I don't know if I want to vote for this, inform them of the fact that what are you going to do with 12.5% or 12.7% inflation over the previous 2 years? We've had discussions about the contract that the governor signed, and I think we heard in Division 1 from Administrative Services, it's been signed. You can't do anything about it. It's 10% the first year, 2% the second year, which now we discover that's pretty much what inflation's been. So you've got to admit that and kind of stick with what we've been handed and still try to find other ways to spend. Some people have said, gee, do we need all these employees? What we've discovered through the years is there's some more efficiency in government. At one point, there were a lot of people filling out a form, handing it to someone else to fill it out a little differently, handing it to somebody else. Now we have information technology that you can fill it out once, and it gets populated to wherever it needs to be. I am still waiting, and for about now 20 years, for the Business One Stop, which we've talked about. Some of us have heard about it for year after year after year. Some years ago, my daughter opened an ice cream stand, and I said, ice cream shop. And I said, how'd that Business One Stop work? She said, what are you talking about? I said, didn't you just fill out one form? You're crazy. I had to go 3 places on Health and Human Services, 3 places on Department of Revenue Administration, 1 place on DOT for entrances and exits, and 1 place with the Secretary of State to okay the name of the business and see that it wasn't duplicated somewhere else. So I am told by one of the people that works on that sort of thing at the governor's office that now they have put out a contract for Business One Stop. Now, I think the reason it was slow walked all these 20 years is because, well, we don't want to lay out this receptionist. We don't want to lay her off, or we don't want to lay off this person that passes out the form. So that may save us a few jobs, and these efficiencies should continue. We've got information technology working on that sort of thing, and we will encourage them when they come into us to keep it up, because that has been what's made manufacturing and everything else in this country far more efficient. So look for those things, and if they say, another thing I've discovered is, oh, we've got a lot of vacancies, but when I asked the treasurer for a count of the paychecks, it wasn't that short of what it had been in the past. So keep an eye on that. I think it's available to us, the number of checks that go out, and I think it's by department. So if they come in and say, we need a lot more people, and you say, well, you've got the same number you've had for years, and you should be getting more efficient every year. So why do you need so many people? So look at those things in the next week if you're going page by page through the budget. Of course, as always, the general fund pages are the ones we have to pay the most attention to. There are many things that are funded by their own sources, like banking and insurance, and we hope the highway fund will keep the Department of Transportation going well. So maybe we don't have to put as much general fund in there. Fish and Game called me the other day to say that, this 10% pay raise, they have their own funds. They get them through selling the licenses. And they did have a great year a couple of years ago when everybody couldn't go anywhere because of COVID. So they all went hunting and fishing or whatever. And so they had a very good year, but it hasn't been as much since. So they're starting to whittle away at that surplus they had. They didn't think they could afford to give the pay raise, the 10% pay raise to all the employees they have. And they said the governor promised them that it would come out of general fund. So Division 2 will be working on that. And I know Mickey will be involved, taking a look at that and see if it in fact is in the Fish and Game budget, that pay raise is there. And so those are the kind of little nit noise that we got to worry about. I was very unimpressed with HB2 and all the things that went in there without, in my mind, very clear thought. When you say we don't need surveyor licenses anymore, and those of us that have been on a planning board or dealt with the Register of Deeds, there damn well better be a licensed surveyor stamp and license on that plan and name. So why do you think you can just easily say, oh, we don't need licenses for surveyors? And similar throughout that OPLC piece, but we will be hearing more from in executive departments and administration, which will be helpful on what they consider that. And a lot of those things are like one particular, oh, we never get any complaints about them, so why do they need a license? Yeah, so, if we don't have any complaints, so we don't have to take your license away, why do they need a license? Well, because somewhere's in the law, some places in the law, it might mention it. And if you haven't looked all those places up, then, and some of it might be in town ordinances. I know a lot of that stuff on, like the surveyor's license was in my town ordinance, and we'd have to look at that at planning board. So a lot of little places, we learn as we go. It's a great learning experience for an old man like me that new things keep popping up. Give me a few more brain cells working. So I hope it works for you as well. Did you have any more comments? Or Mr. Ripple? Vice Chair Erf.
Does anybody plan to write a minority report for those that had minorities? No? Okay.
If so, we need to have it marked and we need to have it in the next few hours or few minutes. Don't make Janice stay late and hound you for it. I know that Representative McGuire has written most of them, so congratulations, and he's got them already. Thank you all for your attention. Thank you all for your patience. I guess Division 2 is going to meet. Are any of the other divisions going to meet? Not 1, not 3.
Division 3, 9:30 Friday.
We're going to start at 9 o'clock for the session tomorrow, 9 o'clock. So we'll try to cover a lot of bills. Thank you all. We are adjourned.